Pyom, 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 pyom. Hello, 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 how are we today? Hello, hello, how are we today? Today. Don't know why, that's my head. I don't have no idea. I just turned it into hello, hello. So, hello, everyone. I am so prepared. No wrong one. That one. Is that the one? See, see the loyalty. See the loyalty. Look, this is what we're looking for, yeah? Look at that. Sarah P in the house. Hi, Sarah. Happy Monday, everyone. Hope everyone had a great weekend. Yes, I hope you had a lovely weekend there. Hope the weather was nice. The weather is, well, was awful here today. Must be a nice, quiet weekend. I streamed Saturday night, as you know, well, Saturday afternoon for you. But it was like, yeah, it was nice to have a day off yesterday. No streams, no nothing. So, yeah, lovely jubbly. Do you know what I mean? I'm excited for today. I'm trying to get the right setting here. Don't That's the setting I was looking for. So yeah, good morning to you, Sarah. I know it's about 9 a.m. for you. It's 3 o'clock in the afternoon here. Whoever else is here, good morning, good afternoon, good evening, wherever you are in the world. I'm not sure where we are. We'll always give it a little bit, 10 minutes to see if people do come in. But we're in a wonderful day today. So we got this now part two, the rest of day one of the ballerina trial and the day two, the defense. And then this evening or this afternoon, we got a video of Lou, which I know Sarah P has seen it already. You've seen the video. I was trying to get Lou on, but she's working, so she can't make it, unfortunately. But she did say if there's any questions, she's happy to come on and do a live stream with me anytime. So that'd be good. But I wanted to promote to the channel. I think she's got great stuff on that channel. So we're going to still do that today. And tomorrow, got Johnny Depp. Johnny Depp tomorrow. And I know that Solomon is doing a stream with Viva as well. My plan with that, because it's the same time as Johnny Depp, I know that most people are going to go and watch it, and that's absolutely fine. But I'm not going to disrupt my stream for it in the sense of I can't because my playlist will muck about. So my plan is to play it afterwards, um, later in the evening, which is good for me because I can't stream Johnny Depp, watch that, look at chat, listen to what they say. I can't do it. So I'll have chat open and say hello and everything. I make sure that the numbers are there, but I can't listen to it. I get too distracted. So I will refilm it for those that are unable to watch it later in the well, about 4 o'clock or whatever afterwards, hopefully. But as I say, I suspect that most people will go and watch it live anyway, which is totally fine. I probably would myself, to be fair. Um, so yeah, morning, Kim. How are you? Oh, another one here. Hope you're well, Kim. I was just saying, I'm probably not going to watch the Solomon interview tomorrow live. But I know like you're 100% watching it live. But I'll probably have it open in chat. But I'm going to stream it after the Johnny Depp stream at about 4 o'clock Eastern to listen to it clearly because I can't do more than one thing at once. I'd rather listen to it properly afterwards. So yeah, we'll do that. So that's the second chance for you to watch it if you wanted to watch it a couple of times as well. But you guys might be more organized than me. I can't do more than one thing at once. Oh, not until very late tomorrow. Is it not? I thought it was at 1 o'clock tomorrow. I thought it was 1 o'clock Eastern tomorrow. Hang on. I thought it was at 1 o'clock Eastern. Bam, bam, bam. I got it somewhere in Discord, I'm sure. Bam, 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 bam. Bam, bam. I need to get a better handle of Discord. I do because I don't. People just put whatever the fuck they want. Right. Is that my one? Yeah, Discord. Right. Mm-hmm. Let us have a looky. Where is it? Dee dee dee. I can't not find it. What is wrong with me? Me. Beep 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 beep. I can't bloody find it. I'm pretty sure. I'm pretty sure. You know what? I've been looking at these. This is what I mean. I need to get better organised here. I can't even find the bloody thing now. Oh, here we are. Zachariah Anderson. Um. Oh. Oh. There's no time on it. Hang on. Let's go on the Zachariah Discord. Jen's posted it, so I'll. Where? Oh, this is trouble with Discord. You can just get lost everywhere. It's just too much stuff. Like people just post shit and you just lose it. I can't. I don't even know where it is now. Need to reorganize Discord. Um. I know that Jen posted it, but oh, hang on. I'm gonna have to go on Facebook and I can't sign up for Rumble. It keeps giving me an error message, so I have to wait for you to stream it. It's on Rumble, is it? Oh, I didn't know that. Oh, let me go Facebook. Let me have a look here now. See. Um. Let's have a look. Dee 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 dee. Here we go. Free Zachary Anderson group. Do 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 do. Oh, right. Where is this now then? Solomon and Viva Vrey. 12 o'clock Central. Online events. There's no link to or anything. So yeah, it will be 1 o'clock Central. So will be uh 12 o'clock Central will be at 1 o'clock our Eastern time. Uh yeah, 12 o'clock Central, Jen says. Fine. There's no link to or anything. I didn't know it was in Rumble. Right. I don't think Viva has it up yet on YouTube. I looked it for this morning, couldn't find it yet. I saw on Twitter this morning says this. I want. Yeah, there we are. I got the same message. I've got it. So yeah, 1 o'clock Eastern. 2, 3, 4, 5, 6. So that's 6 p.m. my time essentially. Um, so my plan is to stream it at 4 o'clock Eastern, or even 3 o'clock Eastern, whether it's for Rumble or YouTube, whatever. But obviously, I know, like you, Sarah, I know you're going to be watching it live, and and Kim, if you can't, then don't worry. I think you'll have it on YouTube though. Yeah, I'd be surprised if it was not on. It depends. It depends with Viva if like anything semi controversial for him, he might not be able to do YouTube. And not that it's controversial, but it's a subject matter that YouTube might. Some people aren't going to like it, so it might just be Rumble. Whatever happens, if it's YouTube and Rumble, hopefully it's on both. I'll open both. Um, you know, um, I if so and I'm definitely doing joint depth at the same time, but I will open Rumble and YouTube at the same time. But I won't. I'll have them both on mute. But I'll say hello in both. Um, but then I'll stream it on here for those. But even those I have watched it already, they might want to watch it again, as in because it's hard to dissect first time and stuff. So, But anyway, that's the plan anyway. As I say, I don't expect people to stay around here when it's on. I expect to have probably 0 viewers here, and that is fine. As I say, in your place, I probably would be doing the same. So yeah, I'm doing straight after dep, doing straight after dep. So once they finish that, I'll do it straight on after dep then. So I imagine dep's gonna be finished about 8 o'clock. So I'll probably do it about half 8, 9 o'clock then on. Because I want to keep them separate. You see, I want to keep Depp separate to that. I want to do like playlist for Zachariah, playlist for Depp and stuff. So whatever happens, I'm playing it anyway. So if it isn't on YouTube, Kim, don't worry, I'll have it. So don't panic about it. I will definitely have it anyway. And if it's on Rumble, I'll make sure that I open that and say hello and stuff in chat so that I've got some presence there. But yeah, I'm not going to watch it live just because of the depth trial. So I don't want to confuse stuff. Had I known this was happening, I could have done things differently. Um, but you know, yeah, you know, I don't know. I don't know what I'm trying to say. Just read that Nicole has only passed the bar 4 years ago. Okay. Well, I mean, that's highly impressive then because I thought she was very good. I thought she was very good in the trial. But I'm biased. I love Nicole, so could very well be biased. There, I need to look at it through again. I have started going through it again, um, and it's looking all right. All right, hang on. Right. So anyway, just so you two know, I know you're big Zachariah followers. I'll definitely play it afterwards. If you want to watch it a second time, and Kim, if it's not going to be on YouTube, don't worry. I will have it straight after it's finished, probably. Bang on here. Yeah, Sarah, I totally agree with you. I didn't realize she had limited experience, but I thought she was a pro. To be quite honest with you, I thought Nicole was a pro. Um, I don't think she's got an aggressive nature that phew, she fights for her clients. That was my impression anyway. So, and so today we've got a few other people here now. I don't know who is here, but today we are having the trial. I don't remember the trial now. Ashley Benefield. There's a Benefield. There's a singer called Benefield, is there? Benfield? Banfield? Benfield? Benefield? Danny Benefield? No. I saw on video on YouTube Nicole Muller #1 fans. Yeah. I still Natalie Wislow, I still like I couldn't believe it after the trial, 2 months after the trial, she told me that she sent all my videos to Nicole every morning. Um, I had no idea that was happening. I'm glad I didn't know it was happening. Because can you imagine if I knew that Nicole was looking at it every day, I would have been nervous then. I couldn't have done them. So, yeah, so that's funny. Considering a guy who sat here in Wales, in West Wales, is making videos about a top tier trial and an attorney in Wisconsin, and she's watching them every morning before trial. Madness. Madness, I tell you. But it's quite cool as well. Right, let's have a look here now then. So, this trial, we have got 5 hours, right? But it's not going to be on for 5 hours because we are 1.5 in it. Do make it go quickly, 1.5. And if you're going too quickly, we could do 1.25. I think she did a good job, not great. She did a great job for such little experience for sure. You know, what? I don't, I wouldn't change anything she did from first glance. I thought she was terrific. I thought she was the exact lawyer he needed. You know, not every lawyer fights like she did. So if I was ever in trouble and needed a defense attorney in that area, she'd be the first call I make. Not that she can help me because I'm in another country, but if I had that option, I would. So let's wait one more minute. One more minute. And then we're going to start this. So this is half after lunch of day one, and there's an hour or 50 minutes from day two um, left on this. Then we're going to have a little bit of a chat, see what we're doing next, and then we take it from there. I think there's only 5, 6 of us here, I believe. So don't be shy, say hello and chat. There was more they could have done, but they may not have been able to do the previous route. Absolutely. Yeah, I think they were from speaking to Solomon. That's true, apparently, because of previous rulings and also because of what the DA was doing. They were sometimes limited what they could put in. Also, you remember about the jury, they see the jury, they see the reactions, they see the judge, maybe leaning towards the state a lot. So it's easy, I think, for us to look back. Oh, they should have done this. We don't know everything, so there was so much more she needed to get in. If I'm being honest, on popular opinion, she needed to dress more professional. Imad, I don't know. Hey, everyone's got an opinion, Kim. Everyone's got an opinion. I actually thought she's quite professional, but I'm a man, so do you know what I mean? My, I actually thought, yeah, my opinion doesn't really count that there, but I thought she was just quite professional. But I get your point, and this is why we're all different. That's why it's good. Right, with that, let's start this bad boy. Ashley Benefield, Danny Benefield. Oh, that's gonna bug me now. But anyway, here we go. Here we go, Warriors. Here we go. Boom, boom. Oh shit! I need to put this in. Right. Well, I can't hear anything so far. So hoping the court's muted. Hopefully. Right, I can bang this forward. Um okay, working. Here we go. Let's witness.
Hello, sir. Hello, sir. As the deputy said, 12 to 15 inches from the microphone. Okay. Adjust it how you need, up, down.
Right, that's just too quick. I need to go start off with 1.25. That's way too quick for me on a Monday morning. I put subtitles on. Oh, wrong one. I'll put subtitles on English. I'll adjust that. That was just way too quick. He just came in from the whoosh. We'll change it back once we get used
Down,
to it.
left, right, and just loud, clear voice should hear everything.
Yes, sir.
Thank you.
And Judge, we're ultimately going to need the screen. Good afternoon.
Good afternoon.
Please state your name.
Detective Justin Warren,
How do you spell Justin and Warren?
Justin Warren.
Where do you work?
I'm employed by the Manatee County Sheriff's Office.
How long have you worked there?
Started March 25th of 2003, so just over 20 years.
What is your current position?
I'm currently assigned to the Manatee Homicide Investigative Unit.
What is that?
So basically, it's a unit comprised of detectives from the Sheriff's Office as well as other local municipalities. And whenever a homicide occurs within the jurisdictional boundaries of Manatee County, several of our detectives will go out to assist.
And generally speaking, when there is a homicide, do all of the members go out?
It depends. Sometimes for people on vacation, other times not everybody will come out. It depends on what the supervisor deems necessary.
But the majority of the time, do you have more than one detective there?
Oh, yes, ma'am.
Okay. And do you have what's considered a lead detective in cases that you do?
We do.
Okay. And what does the lead detective do?
The lead is essentially the person who will basically hand out assignments. Those other detectives that will be out at the scene, or they might be knocking on doors, talking to witnesses, they essentially report back to the lead and the sergeant.
Okay. So as the lead, even though you may be designated the lead, that doesn't mean you're doing all of the interviews.
No, that's correct.
Okay. Were you the lead detective on the case that we're here about today?
Yes.
Ashley Benefield?
Sorry, yes, ma'am.
Yes. On the date of the shooting, were you notified?
I was.
And around approximately what time?
I think it was probably around 7:20 or so.
Okay. So you were called at around 7:20. Do you know, was there a 911 call?
Yes, ma'am, there was.
And what time was the 911 call?
I think that was approximately 18:56 hours, so 6:56 or so p.m.
So you're there roughly 35 minutes, or,
Yeah.
or you come to the sheriff's office roughly 35 minutes afterwards.
Yes, ma'am. I started responding there.
Okay.
Yeah.
So I was starting to say that you went to the scene, but you didn't go to the scene first, correct?
That's correct.
Where did you go?
I went to the sheriff's office so that we could begin authoring a search warrant for the residence.
Okay. At that time, did the defendant, Ashley Benefield, come to the station?
She was brought to the station. Yes, ma'am.
Okay. Was she brought to the station by other members of Manatee County Sheriff's Office?
Yes, ma'am. There was a patrol deputy brought her in a marked patrol unit.
Was she under arrest at that time?
Not by me, no, ma'am.
When you saw her, were there any other people with her?
When she arrived, it was just the deputy and her. But I was soon, actually, before I even met with her, I was actually approached by a female by the name of Faith Brown.
Okay. And did she have other people that joined her throughout the evening?
Eventually, 2 others arrived. Yes, ma'am.
Okay. Do you recall who they were?
Leland Taylor and a Miss Kimberly Kuhn.
And they're all 3 attorneys?
They are.
At the time, did you have a crime scene technician take photographs of her?
We did. We had a crime scene technician respond to the office. We actually obtained a search warrant in order to get those photographs and DNA and whatnot. But yes, we did.
And why?
We asked, and initially it was told by her attorneys that they would rather us get a search warrant, so we did.
Okay. And why did you want pictures?
So initially, when I saw her, I didn't notice any kind of injuries at all. I didn't notice anything about her clothing that stood out, whether it was ripped or torn or stained or stretched out, things that you would typically see during a physical altercation.
At the time that you saw Ashley Benefield, were you aware that there was a self-defense claim?
I had been aware of what had been said on the 911 call. Yes.
Okay. And what was said on the 911 call, and we have a stipulation to this effect, but basically Ashley went to a neighbor and said her husband attacked her.
Correct.
Okay.
And yes, ma'am.
So you were aware of the self-defense claim at the time.
Yes.
When you observed her physically, what was she wearing? Oh, I'm sorry.
I request that the stipulation be read. Which one is it?
It's number one, I think.
Number 1?
Ooh, stipulation.
Okay, it doesn't mention 911, but that's ran to neighbor's house, called 911.
Well, Your Honor, I believe it says immediately
Mhm.
ran to neighbor's house
Yes.
and hysterical.
Mhm.
Just quite different from what was repeated.
Oh, okay.
Okay.
I've read it.
So anyway, I'm sorry, this is repeated, but you did understand there may be a self-defense claim at the time.
Yes,
Okay.
ma'am. That's accurate.
So what was the defendant wearing?
Like if I remember correctly, it was like a I don't know what you call it. I guess like a crop top, tube top, something like that, almost a sports bra kind of thing, and a pair of shorts, if I remember correctly.
Okay. So tube top sports bra kind of thing.
There was some midriff that was visible,
exposed.
exposed.
And you said you looked at her clothes
I did.
and you didn't see anything torn or disheveled.
No, ma'am, I didn't.
Okay. And when you looked at her, did you see any injuries?
I did not.
Did you look specifically for injuries?
I was paying attention as we were standing there in the lighting out in front of the office, and then on the way up to the interview room. And as we walked her into the interview room, I was paying attention to that. Yes.
Did you see her face clearly?
Yes.
Did you notice any injury to her face?
No, ma'am.
Did you speak with her attorneys about the need for documenting these injuries or,
Yes.
or lack of injuries?
Yes, ma'am, we did.
Okay. And that's
Oh.
when you got the search warrant, correct?
It is.
And did you have an opinion about what you should photograph?
So my initial opinion was to photograph everything to make sure that we did a thorough and accurate job in documenting any injuries or marks that may be present. And we actually even put it to her attorneys. And I asked them, I said, if you wouldn't mind, go talk to your client and try to help us determine if there are any areas of injury or any areas, because we're going to do DNA swabs of the skin as well, to try to pick up any foreign DNA, foreign to her. And
Any response, Your Honor, I think we're heading into a dangerous area.
Yeah, I don't know if you're going to start talking about attorney-client privilege information or.
No,
Okay.
no, I just wanted to get across that this witness asked the attorneys, where should I photograph, and then what the response was. And that's
Okay.
why,
All right, I'll overrule.
so you asked, should I pay attention
right.
to any areas
Yes.
and go talk to your client and let me know?
Yes.
And they came back and said what?
Arms, legs, neck, and hands, I do believe was the final.
Arms, legs, neck, hand. Did they ever mention, or did anybody ever mention to you eye or face?
No, ma'am.
Did anyone ever mention
interesting.
to you midsection?
No, ma'am.
Did you ultimately arrest her that day?
No, no, ma'am.
Why not?
Because she had made that claim of self-defense. We wanted to make sure we conducted an accurate and thorough investigation. There was obviously a lot going on here with her past history, and we wanted to make sure that we did a thorough job.
Okay. So you said with her past history, so at least you were somewhat aware of some previous reports.
Yes, ma'am. There were some reports that were in the Manatee County Sheriff's Office computer records database that we were able to view.
Okay. And did you ultimately get another search warrant to take pictures of the defendant 3 days later?
We did.
And why did you do that?
Well, sometimes with injuries, they don't readily show up right away. Bruising sometimes doesn't come up initially. So we wanted to make sure that we did our due diligence again and check 3 days later, giving those injuries time to appear.
Okay. And have you
I like that. I like that. Not many people do that. I've never heard of any other trials where they do that. I like that. That you take pictures of first on the day and then you go back in like 2-3 days and do it again. That's very good. I like that a lot. That's impressive. That's good. That's good police work.
seen those photos?
I have
Do you recall how many photos were taken?
of her in total.
Yes. Let me be more specific. So the first day and then 3 days later, there was more taken. So together, about how much?
100 or so.
Okay.
Something like that.
So a lot of pictures.
There were a lot. Yes.
And did you at any time, either at this first meeting in the sheriff's office or after the fact, see anything on the defendant that appeared to be an injury?
There was a small scratch. I believe it was on her side. But that actually came up during an interview that we did later on, and it was very minor.
Okay. As part of the investigation, was Doug Benefield's phone taken into evidence?
It was.
And was that phone searched or downloaded to gather the information?
It was. It was taken to our technical services unit, and they did an analysis on the phone.
So you don't do that?
No, ma'am.
Okay. So once the information is downloaded from a phone, is it in some sort of a format that you can read it and search it?
They do use certain programs that allow you to search through and help organize what you're downloading. I don't know the exact ins and outs of it, but I mean, I'm capable of using the program and reading through it, but
Okay.
I don't know the technical aspects of it.
Did you review certain information, some information from his phone?
Yes, ma'am.
And did you find anything about a U-Haul on his phone?
Yes, ma'am. There was a confirmation email that a U-Haul was supposed to be picked up locally. Then I believe it was supposed to be dropped off in the Bowie, Maryland area.
Okay. And were you able to examine his searches on his phone?
Yes.
And did you find anything interesting about his searches?
Yeah. So during one of the searches was actually, it looks like he was looking for a roommate. Like he was looking for a place to move into. It was like roommate finder or
Hey,
something
me.
along those lines. But in the Bowie, Maryland area.
And why did that seem of importance to you?
Well, some of the information that we'd received was that everybody believed he was moving in
Okay.
with them. And obviously this kind of contradicted that.
Okay. Moving in with them, meaning Ashley
And
and,
her mother and
mother.
their child.
okay, in Maryland.
Correct.
I am going to.
Okay. Search as well.
45, and I know there may be objections to this. These are the text messages. There is a stipulation, which I think is number three, that this does not need any further authentication. But I don't know if the defense has a further objection.
That's correct, Ron. We stipulate that it's authenticated. However, we still preserve any appropriate objections, one of which includes hearsay and two references.
Yeah, it is. It is, Amy.
And Judge, generally my response is that these are text message exchanges between the defendant and the victim for the 7 days right up to an hour before he's murdered. While there may not be anything, explosive on these text messages, that is the reason I'm putting it in, is that there wasn't any fighting going on. There wasn't any.
Question, Your Honor?
No, I'm.
I think she's just responding to the objection.
Yes. It is to show the nature of their relationship leading up to the incident. It's expected, and because of what is written in the stand your ground motion, the state feels it's necessary to show the tenor of their relationship and how the relationship was at the time in question.
All right.
So,
I guess my first question is, I haven't seen the text. I don't know what's in the text. I wasn't provided a transcript or a printout of the text. So I don't even know what the subject
go
matter
over it.
is. I don't know how many there are.
a few. Yeah, we were going to go through it, and the detective was going to help me read these.
Right. I don't know how to make a ruling when I haven't even seen them yet. Maybe they're hearsay, maybe they're not. Well, we've got defendant statements at least for one side of it. So
Okay, those are two interesting points. So we got more people here now. Oh, hello everyone. Hello Amy. Yes, this is a stand the ground trial. It was from last week, but we're just catching up now. The final day 1 and day 2. Good morning, friends. Good morning, Toxic. Wait a minute. When I was giving her a wrench, Banshee was doing such a great job, so we said, look, let's give her a wrench. Let's give Banshee a wrench. And then, obviously, I would have given you a wrench a while ago, but I just thought you were too busy. But blame Banshee. He said that you'd love it. So, yeah, congratulations. I think you'd be a great asset, as long as you don't mind doing it. I know you got other stuff to do. Did everyone hit that? Hit that like button. There we go, Kim. So yeah, we'll need to have a chat, Toxic, on you're now a mod on the Discord as well. I need to change that a little bit when Spidey's here as well. So right, there we are. So yeah, congratulations. And so is Sarah as well. Sarah's a mod now as well. And welcome back, Amy. Not been here for ages, Amy, it feels like. So nice to see you again.
is the other side of the conversation being offered for the truth of those statements, which
No.
would then be hearsay, or is
No.
it just to show the natural flow of the conversation?
Oh, no, the Florida
That
one. I
conclude-
didn't
I don't
use
know.
that.
Yeah, I do think, Your Honor, it has to be relevant to some fact in issue.
And then you got relevance. So
Yeah, and it is not.
And
I don't know how to make this decision without seeing them.
I was gonna. I think it's. I'll write some stuff in the admin. There's a few things that I'd like to see changed. That's all. Nothing specifically for you. It's just more that annoyed me. Not you didn't annoy me. Just some stuff on Discord annoyed me, but it was nothing that you have done. So it's all good. So, but I didn't want to say anything until I'll drop it in admin. I don't want to say anything until I spoke to you, and now you're here. I'll drop it in admin.
And I do have some further argument depending on what the actual objection is and what the response is.
So what I'm thinking is going to happen is that we're going to keep going pursuant to, or I'm sorry, subject to your objections, but I got to see them to even have an idea how to rule.
I understand. So, Judge, we can continue.
I left my quarter upstairs.
We can continue on as the court suggested earlier. I'm confident the court will.
All right, thank you, sir. So this is subject to any objections.
Okay. And if we could just dim the lights a little bit right in front, just the ones in front of the screen would be okay. And the state would enter into evidence states exhibit 45. I don't know that I actually did it after the objection. Or would you like me to wait?
Yeah, we're gonna
Okay.
have to wait on all of it.
Okay, okay.
Now, ultimately, even if I don't allow them, I imagine you're going to want to put them in
Right.
the record for your proffer and appellate purposes. But for right
Right.
now, I'm delaying ruling on all that.
Okay. Now, you have a pointer right in front of you.
Yes, ma'am.
Yeah, if you wouldn't mind. It's really hard to see on this screen, so I'm going to zoom in a little bit. Let me go all the way to the top. What are we looking at here? If you could just tell us what information is in this.
So this appears to be a timeline of text messages. Down here, it's telling what type, because there are different types of messages, instant messages, and depending if you have an iPhone, it might be an iMessage or an SMS. Over here shows the direction of the call or in or text message, whether it's an outgoing or it's an incoming. This would be the date that it was sent, and sent, and this would be the sent or received, I should say. Then this would also be the date and time. Then obviously direction from and to, and then the owner's information of each phone.
So are you aware of the reports that came into the sheriff's office? We heard testimony earlier about it from Stephanie Murphy, that there were at least 5 abuse complaints against Doug Benefield, saying that he was abusing the dog.
There were several, yes, ma'am.
And were all of those complaints before this date of 9/20 of 20?
Yes, ma'am, I do believe so.
So I would like for you to just, I'm going to make it a little bit bigger. If I'm just going to have you go through some of these so we can get sort of the tenor of what's going on here. So the ones in light blue are from who?
Okay, so the ones in light blue are from Doug Benefield,
And 2,
and they would be to Miss Ashley Benefield,
and the orange.
and the orange are from Ashley to Doug.
Yeah, it might be better, if you look up here, you might be able to, the video. Okay, so the first instant message is 9:20 of 20 at what time in the morning?
9:20 of 20 at 8:20 a.m.
Okay, and now it looks like there may be not a message necessarily, but an attachment.
Correct.
Okay, so now, you've seen this before. So do some of these attachments work and some do not?
Some, yes, ma'am. Some of them do, some of them don't.
Okay, do you know why that is?
I think 'cause some of them are actually based on the internet, not something that's downloaded. So sometimes if you're not connected, the link won't work, and
Okay,
various other reasons.
so this is the first one. And what is this?
Looks like a Bible verse.
Okay. And that was from Doug to Ashley, correct?
Yes, ma'am.
Okay, and then if you could just go through the next few lines.
Okay. On 9:20, so the same date, 10:36 a.m. Loved an image. So typically with some images and posts, especially with iPhones now, they really have this thing going where you can actually laugh at an image or love an image, or you can do different reactions essentially. So as far as I'm aware, that's what we're actually when it says loved an image. I think it's her reaction to that.
Okay,
Most recent text message. 10:36 and 36 seconds. So 5 seconds later, she sends a message. Good morning.
and then he says,
He replies with good morning.
and then within an hour after that, there is what looks to be an attachment. Is that one that you're able to open?
I'm not sure if that is or not. I don't think it doesn't have a line under it, so I'm not sure if we're able to open that one or not.
Okay, so then the next text message is from,
This one's going to be from Doug to Ashley. It says, "Run, baby, run."
and if you could just continue down the line.
Sure. Then Ashley sends a message, laughed at a movie. Ashley sends some smiley face emojis. That's what they look like. Doug replies, "Ready to rock and roll, laugh out loud, question mark." That was at 12:20. At 12:31, she replies, "Give me a few, LOL, trying to round up the cats. It's like trying to teach ballet to squirrels."
Okay, so I'm just going to scroll up. What's the next entry?
So within, looks like within seconds, he responds, "Ha, that's funny. Give me a few, LOL." He's basically saying he liked this comment. So essentially, like I said, it's a reaction to the comment that was given.
Okay, and then he says, or the next entry is her. What is it?
Yes. So at 1:06 p.m. it says, "OMG," or "Oh my God, I'm exhausted, LOL. You can come over now."
Okay.
Sorry.
And at this time, it's your understanding they were living in separate houses, correct?
Yes, ma'am. He had an apartment down the road. I believe it was called the Green.
Okay,
And then she was in a subdivision.
so this here is Ashley telling him you can come over.
Yes.
And he says,
Sorry. He replies, "Ha, need to video the rodeo. Okay, headed that way."
okay.
That's at 1:08 p.m.
And then she likes a comment, but then at 1:20, what does he say?
So at 1:20, "I'm walking around to back.
And she says,
I can let you in the front or whichever." He said, "Okay, front's good." Then she gave him a little thumbs up.
okay, so that entry was at 1:22 p.m. The next entry is several hours later at 5:37 p.m., which appears to be from Doug. What does it say?
Me and XS boxes arrived
All right. And Ashley's response?
is LOL.
Okay.
Then it looks like at 6:40, Doug sends some other type of an attachment to her.
Okay, and we'll view that attachment.
I don't even know what it's doing. I think it's giving you clues that I gotta guess. Get real. Real.
Working mother, not a working mother.
Working mother, not a working mother.
Not a working mother. I live in a.
Oh no, it's running out of time. House. Real house. White. Oh, housewives of. Oh.
So the person on the left, that's Ashley, correct?
That's correct.
And then on the right, do you know who that person is?
That's her mother.
Okay. Then at the next entry is about 40 minutes after that one is what?
Let's see. We have, was there a response to that? I'm sorry.
It's well, I'm sorry. It looks to be a call log phone
Yeah.
call. Yeah.
So that looks okay. So yeah. A call log. Sorry, incoming. It looks like there's about a 13-second call
From Ashley.
from Ashley
Okay.
to Doug.
And then the next entry.
Next entry is from Doug to Ashley. It's 9/20 of 2020 at 8:58 p.m. And it says, "Good night, sweet Theta waves. I'll be done by 1 tomorrow and plan on joining the party."
And she does what?
She loved the message at 9:22
And
p.m.
then said,
And then good night. I'm sorry. Good night. You sure went. So you sure want to come hang out at the slum? Or you sure you want to come hang out at the slum? So basically indicating what they were joking about in the video.
on the video. Okay. And his response.
Yep, be smashing at the slum.
Then skip down. The next one is that she liked that message. And then the next entry is from Doug at what time?
That's at 7:36 a.m. on 9/21. So the next morning.
The next morning. Okay. And there's an attachment.
There is.
Okay. And we'll look at the attachment. And for the record, what is this?
That's another Bible verse.
Okay. And what's the next entry?
The next thing I see is at 9:55 a.m. Ashley loved an image. Then she says, "Good morning."
Okay. And what does he say?
Doug replies at 9:56, "Good morning." And there's some little emojis behind it here. Then later at 12:46 p.m. Headed that way in about 30 minutes.
Okay. And her response?
Her response, that's at 1:09. Oh, hey, wow, you done for the day? Don't rush because of us. We're out for a walk now. Not in a rush to get started today. LOL. We'll have to round up the cats when we get home anyway.
And his response?
So his response at 1:13. Oh, nice. A little breezy, which helps. Getting an early start so can finish up early to come over and be with y'all and play with Emerson for y'all up some. Just ping when good to head over.
And she likes that.
And she likes that at, yes, 1:51.
And says?
Then at 1:51, a few seconds later, will do.
And then she also asks him?
So yeah, 2:47. Want to grab a can opener at Publix on your way over? LOL. I, of course, packed the one that we had.
Okay. So I'm going to run a little ahead. So this is the next day. If you could read that, what's at the top, that date.
All right. So we have an outgoing from Doug to Ashley on 9/22 of 2020 at 4:11 a.m. And it looks like it was an attachment that was sent.
Okay. And we'll look at that. And for the record, if you could say what that is.
It's another Bible verse
From Doug.
from
correct.
Doug to Ashley. Yes.
And then he says,
Sorry. Then he says, "Good morning. Hope you slept okay."
and her response.
Looks like she loved the image and then replied with "Good morning."
Okay. I'm going to scroll up.
I'm presuming they've got rid of those numbers because we just see their mobile numbers. How easy is it to change the numbers? Because Ashley's is right there.
About
Could phone
later
her.
on that day at like 1:36, which is the top entry, and he says to her,
So Doug sends Ashley a message. Can you think of anything we need at Lowe's or anywhere?
and the
So-
next,
After that, at 1:42 p.m., it looks like Ashley reaches out to Doug via phone because there's a 48-second call.
okay, so it's a phone call.
Correct.
And then the next entry,
The next entry is at 3:23 p.m. and it's from Doug to Ashley. Headed that way in a few. I'd nothing need.
okay. And I'm going to scroll up. And I want to go to the next attachments here at 9:22 at 9:27 p.m. What is that entry?
So it's like an image, or I'm sorry, some kind of an attachment sent from Doug to Ashley at 9:27.
Okay, and we'll look at that. And for the record, what is that?
It's a picture of Ashley and her daughter on the beach.
And the next entry is right after that,
Yes, ma'am. It's at 9:28 p.m.
and it also has an attachment.
It does.
Okay, and I'll open the attachment. What are we looking at, just for the record?
Again, it appears to be Ashley and her daughter at the beach.
So Doug sent these to her.
Correct.
I want to go to the next yellow square there. What, is that the same evening?
Yes. So 9:22 at 9:30 p.m. Another attachment is sent.
And this is what?
This appears to be their daughter at the beach, and I believe that actually can't see who that is there in the background very well.
Okay,
But it appears to be the same location.
so then I'm going to scroll down till we get to the next day, 9/23 of 20, at 6:47 a.m. What is that entry?
So that is a message from Doug to Ashley, and it appears to be another attachment sent.
What's native? Native message. Because it says source, native message. Does anyone know? Instant messaging. Native message. Is that some sort of like carrier, phone carrier or something? I've never heard of native before.
6:47 a.m.
Okay. And the attachment again.
Is another Bible verse.
And then after that, he says,
So at 9:23, he says good morning. And at 9:28, he replies again and says, got email from Stephanie after she talked to Faith. Since order to mediate, we meet for 1 hour tomorrow to stop court next week. You dismiss injunction. We sign joint stipulation to dismiss dissolutions and hold until Moreland signs order for report. As soon as she signs order, we file dismissal and we're done.
and what else did he say?
At 9:30, and we have joint session with Dr. Q Friday to wrap up our adventure in Florida and leave with understanding of double knots and red-blue inversion.
And the next couple of entries.
Okay. 9:49 a.m. She loved an image. Then at 9:49, it was like 10 seconds later, good morning. Doug then actually, it says emphasize on good morning, so her response. Then Ashley sends another at 9:50. Okay, I'll reach out to Faith to follow up on all of the above with a thumbs up.
Okay. And then he likes that.
Yes, ma'am. So at 9:50, he likes that. At 9:51, and we're all done. Or I'm sorry, and we're done.
Okay.
At 9:52, Doug sends another message, and all in first 10 days of Jewish New Year, LOL.
Okay. So
And then she likes that comment.
we're gonna scroll down to the 9:23 or 9:23 at 10:13 a.m. from Doug. What does that say?
9:23, 10:13 a.m. Doug to Ashley. So perfect outside.
And she loves a previous comment, but what is the next comment underneath of that?
So her comment at 10:14 a.m. says, "Oh yay, we should do Selby today."
Okay. And his response?
His response is at 10:14, "Oh yes." Then he responds, "Yum."
Okay. Then I'll scroll through some of this. The message at the top from 11:39 a.m. Who's that from?
So that's from Doug to Ashley. And the text is, Stephanie just sent Faith joint dismissal of everything except injunction, which Faith has to do. Just a one-pager.
And next?
Then he sends another text, what time thinking Selby?
And then she likes the first comment. And then what was her response? to Selby?
So her response at 11:44 was maybe 1:30ish. I'll text you when we are heading that way.
And then he says, let me scroll up here. There.
So at 11:44, he replies, okay, I can come pick you up too. 12:12, he again sends a message, more time with my baby, and a happy face. And then at 12:14, mediation tomorrow by Zoom at 10:30, and be quick.
Okay. I'm just going to scroll up here. So the next entry I want you to read is from 5:53:38 on the same day.
Okay.
And what does he say?
So it's an outgoing message from Doug to Ashley, 5:53. Do you want to get together tonight or in morning before mediation and unify the instructions for Faith and Stephanie? Think we are going to need to keep involved until this is done or will drag out.
Her response.
Her response at 7:02 is, ha, okay, thumbs up.
And his response.
And his response at 7:05, thumbs up, prefer tonight, maybe run over Pandera or in morning or AM, sorry.
And she says.
At 7:24, she says, sure, can do Panera tonight.
And the next entry.
Next entry is outgoing from Ashley to Doug at 7:24. It says 8 ?
Okay. And he
Then-
sends a thumbs up.
Yeah, 7:27, he sends a thumbs up.
Okay. And then they're telling each other good night. Good night, sweet dreams.
Yes.
And the next day in the morning,
So
7:00. Who is that from Doug?
yes, it is. It's from Doug to Ashley on 9/24 of 2020 at 7 a.m. And it's another attachment,
Okay. And for the record, what is that?
another Bible verse.
I'm gonna scroll through. This entry here is 9:24 at 10:09 a.m.
Okay.
Can you read what that says?
9:24 at 10:09 a.m. It's from Ashley to Doug. It says quick and easy, LOL.
And his response.
His response, he emphasized quick and easy, LOL. Then at 10:26, so nice to experience quick and easy finally, LOL.
Okay, so I'm going to scroll again. On the same day, 12:50 p.m., can you read this?
Okay, so yeah, 9:24, 12:50. This is from Doug to Ashley. It says, just to ponder while I finish up, thinking about getting all the cars up there. And I thought was to ship the Cherokee up there by transport, which is $900, and either tow my truck or tow your Jetta. The U-Haul plus the car trailer is about $1,000. That's for the biggest truck, which gives us plenty of room. The option is another pod and tow one of the cars behind my truck. Overall price about the same. U-Haul more flexibility, like taking things straight to storage.
And she says,
Her reply at 1:27 is, okay, things to think about. Maybe best to have you drive the U-Haul and tow your truck behind. Mom and Cats will go in the Jeep, and I'll drive with Emerson in my car.
okay. I'm scrolling up again for the record. And the next day, 9:25. This is 2 days before the murder.
So 9:25 at 5:45 a.m., there's a message from Doug to Ashley, and it's another attachment.
And what is this?
It's another Bible verse.
What is the next entry?
So the next entry is 9/25/2020 at 6:03 a.m. It's from Doug to Ashley, and it appears to be another attachment.
And if you could read what this says? It's
Sure.
an attachment, but what does it say?
Live a life filled with love.
And he says, good morning.
Yes, so at 9:26 a.m., he sends her a message saying good morning.
Right. And then what is the next thing he says?
The next thing he says is at 9:27 a.m., and it says, Dr. Q is at 10:30. Do you want a chai?
Okay. And they go on talking about the tea. I'm scrolling. This is one day before. This is 9/26/20 at 6:43 a.m. What is this?
So this is a message again from Doug to Ashley, and it appears to be an attachment.
And what is that?
Another Bible verse.
And he says,
And he then sends her a message, good morning, at 9:40 a.m.
and she responds,
9:54, she loved the image. Then at 9:54 and 17 seconds, good morning.
okay. And then I'll scroll a little bit. So this is 9/26/20 at 12:27 in the afternoon from Ashley. What does she say?
So Ashley sends a message to Doug, want to come pick me up and we can go get the truck.
And he says,
He replies, sure, heading that way. Then later, let's see, if at 12:41, I be here.
and, it-
Then at 9:04, good night, sweet dreams.
and she likes the image or loves the image. And
Yes.
says good night.
Love the image, and then replies good night at 9:23.
Okay. So the next day, 9/27, this entry is at 6:42 a.m. What is this?
So this is another message from Doug to Ashley at 6:42, and it's another attachment.
And this must be one that we can't open. So he says after the attachment,
So at 10:02, he sends a good morning, some little emojis.
and she loves the image, and then,
Love the image at 10:06, and then 10:06 and 10 seconds replies with good morning.
okay. So there are several short messages, and then at 1:03 p.m., this message appears to be from Doug. What's he say?
So Doug sends a message to Ashley, what y'all working on?
And she responds,
She replies, last cram, LOL, using the big boxes and getting the last loose stuff packed up and ready. That was at 1:15.
and then she also says,
She also says, how's it going over there? Making progress.
and his response,
His response at 1:18, loose stuff should be a chapter in our book, LOL. Got everything out and in garage, ready to throw on truck, except couch, AKA bed, pretty much emptied. Taking Sully to get his shots, then to doggy spa to get groomed and stay until ready to go.
and he says
And
after
then
that,
at 1:19, I'll come there and drop him off at 3.
and then she laughed at the message
Correct.
from him. She also liked the message, I'll come there after 3.
Yep.
And then what'd she say?
Then at 1:20 p.m., great, could you run by Lowe's before you come over? Grab a few more large and mediums.
And he says,
Sure, I need a few too.
she likes that. And then she says,
She likes that. And then at 2:36, just to be safe, let's do 10 of each just for the last bits here.
and he likes that.
He likes that. And at 2:36, he also replies, okay, let me know. I'm sorry. Okay, let me know anything else if think of.
And then she says,
Tape. At 2:50, she replied tape, and then also LOL.
and he responds,
At 2:50, he says, "Ha, okay." Then at 2:51, just finished the vet, headed to the spa. LOL.
And she laughs. And
Correct.
then the next entry.
At 3:45, he advises that he's headed there.
And she says,
She replies at 3:51, "Okay."
then he says,
At 3:54, I'm here out front.
and her response.
Her response is at 3:55, "Okay, 1 minute."
Okay. So he must have left at some point. This jumps 2 hours or an hour and a half. And the next entry is from Doug to Ashley and says what?
At 5:10 p.m., it says, "I'm about to head back."
Okay.
Then at 5:11, there's some kind of an attachment that's sent from
That we
Doug to
can't open.
Ashley.
And then at 5:11 p.m.
At 5:11, Doug sends another message to Ashley. "Everything and except couch and 10 medium boxes and 2 cab. LOL."
And she laughs at that.
And she laughs at that at 5:14. At 5:14, she then sends a message to Doug. "Ha, OMG."
And he says,
And at 5:32, he sends a message back. "Trucker on the way."
and what time was the 911 call again?
Was it 6:56? Approximately.
When was Ashley arrested?
A little over a month after this occurred.
Okay. And why'd you wait so long?
We were trying to do an in-depth and thorough investigation, look at every aspect of what was going on. She had made a claim of self-defense, and we wanted to make sure that we did everything possible to either prove or disprove that.
Okay. Was a booking photo taken of her at the time?
Yes, ma'am.
Okay. And what was the date? Do you recall?
Not off the top of my head, Alex. It was a little over a month.
Okay. Beginning of November?
Yes.
Yes. Okay. Judge, this is the certificate of business records that the state did a notice of for the booking photo of Ms. Benfield.
Okay.
Object relevance.
Relevance is she looks exactly the same as she did in the other two sets of pictures that were taken.
Okay. Go ahead, sir. I'll overrule.
Okay.
I'm just going to put this up.
Yeah.
I don't know.
I'll be honest with you, Sarah. I'm quite impressed so far with the investigation. Obviously, there could or should be holes here, whatever. But what I've seen so far, I think spot on. Spots on.
What number is it?
Oh, I'm sorry. Statement entered into evidence states 46.
Subject to the objections that I've overruled, received.
Okay. Thank you. I have no further questions. Thank you. Oh, Judge, I don't know that we ever got a ruling on 45, but.
No, go ahead and do your cross, and then I'll hear all of the
Don't
argument.
let me forget. So
What was the number on that one?
45,
There we
the
go.
one that there's an objection?
Yes, 45. Okay.
May I?
Yes, sir, absolutely.
Detective Warren, afternoon.
Good afternoon, sir.
So you testified that you were the lead on this case. And a couple of questions I think would be appropriate. The lead is kind of like the quarterback, no?
You could say that, I guess.
And the lead is also the one with the most comprehensive knowledge of the investigation and how it's shaping up and where it's going.
The lead is typically the person that has the overview in mind.
So that's a yes?
I'd say we work as a team, but sure, yes.
All right. And correct me if I'm wrong, but as the lead detective, you developed the theory of the case.
We all actually sit down and look at the evidence. Like I said, I don't go out to every scene. I go out to a lot of them, sure, but we have other individuals that do certain things. So it's really a group effort.
Well, let me ask you this. Do you remember sitting down for a deposition with me?
Yes.
And do you remember that that was testimony under oath?
Yes.
You took the same oath for the deposition as you took this afternoon when you came in before Judge White, no?
Yes.
All right, do you remember being asked the following question on page 9, paragraph 3? Okay, so as part of your responsibility as the lead detective, you would develop a theory of the case, would you not? Answer, sure.
My answer is still sure.
Okay. Now, you've told us on a couple of occasions
Agree.
that
Agree.
you wanted to make sure you did a thorough and comprehensive investigation.
Is that a question?
Yes, sir.
Yes.
All right. And that is because you certainly wouldn't want to jump to a conclusion on any case, much less a homicide accusation.
That's correct.
All right. And as a result of that, you spent quite some time after this incident running down leads and doing the investigation so you could make a fair and objective determination of what, if anything, was to be charged.
Correct.
And that included you investigating self-defense and things of that nature.
Absolutely.
All right. So I'd like to ask Jack if he would assist me on this. I'd like to put up on the screen, if I can now, the warrant that you authored.
And Judge, no, Jack, is there impeachment here?
Yeah, I mean, is this impeachment?
Yes, it's coming.
We need to ask him the question.
Hold on, as to which question so far, the thorough investigation, which,
The thoroughness of the investigation, its objectivity and fairness.
okay. I think there should be some specific questions to impeach with a document. I mean, is there going to be an inconsistent statement or?
Yes, sir. Yes, sir. If you give me a little leeway, Your Honor, I think I will satisfy the court that the questions that I'm about to direct are appropriate, and I will tie it up.
All right. I'm not quite sure because he hasn't answered any questions about the search warrant,
What is,
No, this is the arrest warrant.
the arrest warrant.
Yes, sir.
Okay.
I think the question needs to be a little more pointed. What exactly is this different than? Were you saying this is different?
Hold on, no crosstalk. Just go ahead, put your arguments on the record.
I would like to know what exact statement is being impeached and what he's using to do.
All right, thank you. Yeah, that's my question too. I'm not exactly sure what specifically you're impeaching from the testimony he's stated so far.
Okay. If the court will allow me to approach the witness,
Okay.
I think I can set the predicate.
All right.
Detectives, let me show you this document and ask you if you read it.
Appears to be an arrest warrant. Yes, sir.
And whose arrest warrant is it?
Ashley Benefield.
And did you fill out and execute that arrest warrant?
I did.
All right. And that arrest warrant, correct me if I'm wrong, is a statement by you under oath that you took to a circuit court judge.
It is.
All right. And when we say a statement under oath, same oath again you took before you came into court this afternoon.
Yes.
And you represented to the judge that the facts stated in the attached affidavit to that arrest warrant were true and correct.
To the best of my knowledge.
Okay. Now, if I may, Your Honor, I'd like to put a select portion of that warrant up and ask him some questions. And I will demonstrate.
What's being impeached.
Well, I have to ask the question first.
Right. So generally, the police court itself would not be admissible. So I need to know what the questions are, and then I'll need to see if that's materially different so that it could be used as a
Yes.
impeachment, as a prior inconsistent. I assume you're doing prior inconsistent statement.
Yes.
Okay.
And what I want to ask him about is first I want to establish what he said in the warrant. And then I'm going to show that a select portion of the warrant is in fact not accurate.
All right. Well, I think that's kind of putting the cart before the horse. I think we got to have the testimony here and whatever that testimony is, and then we'll figure out if there is a prior inconsistent statement.
Okay, I understand. So that is the warrant and attached affidavit that you actually served.
It appears to be.
All right. Now, everything that you had to say in there is true and correct based upon your oath.
Based upon everything I know to the best of my knowledge.
Would you tell Judge White whether or not prior to you submitting this affidavit, you authored two prior affidavits, two versions?
What do you mean, two versions?
Did you author two separate and independent versions of that affidavit before you finally settled on the one that is before you?
I worked on the arrest warrant, so I can't. I don't think I ever set anything up. This was the first time.
No? Okay, so you know about Florida's public records law, do you?
Sure.
All right, and you know it applies to the Manatee County Sheriff's Office as well.
Absolutely.
All right, so let's see if you can identify this.
I could just see it before. These are some, Judge, first off, I would object. This is conversation between me and the witness about drafting the warrant. It has nothing to do with what he submitted to the court. This is conversation between he and I about how it should be phrased. So I don't really understand what's being done right now.
Your Honor, these are two proposed prior warrants of the same version that was actually filed that are statements of this witness. And I'm going to show the court the difference between them and what was intentionally misrepresented and intentionally omitted.
To the court?
To the court that signed the actual warrant. In other words, I'm going to show that this witness has materially made prior statements inconsistent with that warrant, and that there were things intentionally omitted from that warrant that were previously included in the other warrants.
All right, so this is where I'm getting confused. If we're going to impeach with a prior inconsistent statement, I don't think you can start that process with an out-of-court statement and then impeach with prior inconsistent statements. It's my understanding we've got the testimony here today, whatever that might be, and then there might be prior inconsistent statements, inconsistent omissions, commissions, who knows? But I'm not familiar with this. Do you have some cases about impeaching a witness who hasn't yet made any statements using 3 potentially disparate out-of-court statements?
Well, I think, Judge, if I can break it down for the court, I think we've had a statement by this witness on direct to the effect that this case took time because this detective wanted to be objective and fair and make certain that a proper investigation was done.
Yes.
And I am going to impeach that statement by showing that he knew otherwise and had already concluded otherwise, and that the statements delivered today in front of this court are false. And I can do that through his prior inconsistent statements.
Can I have them?
Absolutely. Your Honor.
Possibly, if they were prior inconsistent statements, but
I don't know.
I would just also ask for a copy for the state. These were never provided in discovery. I just took pictures of one of them on my phone so I can at least read it, but the other one we've never seen except for briefly this morning.
Are you asking for a Richardson hearing?
I'm just asking if it's possible for defense counsel to provide us copies or something so we know exactly what's going. We may have just done.
Can I suggest maybe, Your Honor,
Yes.
the court excuse the witness?
Sure.
And we take
Detective Warren,
Yes, sir.
the rule has been.
We'll grab a quick coffee,
Step
we're back now.
outside.
Sure.
Please don't discuss your testimony with anybody, your answers, the question to ask, anything like that. All
Yes,
right?
sir. Thank you.
Can I assist the court by leading the court through what I intend to establish?
Well, let me read these first.
It's the highlighted portions, Your Honor, in particular, that I plan to go to,
highlighted portions of what?
the proposed affidavit.
They're not, first of all, Judge, we need to make clear that these are not sworn affidavits. These are emails. So these are not sworn to documents. It's just the proposed. This is the proposed body of the PC.
I understand.
What's going on? We're still chatting about it. Got a biscuit, ginger nut. Dunking my coffee.
Okay,
Matt?
proponent,
Yeah,
you
so
want to
here's what I would,
impeach the detective with the highlighted portions of what I'm holding in my hands.
yeah, let me walk the court through it if I may. If the court looks at the proposed warrant of November 2nd at 2:06 in the afternoon,
Yes,
the court will see in the highlighted portion on the second page that the detective says the day before the shooting, Barbara Russell, Doug Benefield scraped Ashley Benefield with a box. Then if the court looks at the second proposed warrant, which is approximately an hour and a half later on 11/2/20 at 3:37 p.m., instead of Barbara Russell, her name is now removed and she's no longer an identifiable witness. Now it says the day before a witness, and it says Doug Benefield scraped Ashley Benefield with a box. Then if the court looks at the actual warrant that is submitted on 11/4/20, it says, Judge White, the day before the shooting, a witness, no longer Barbara Russell, explained that Ashley Benefield was inadvertently scratched when someone, no longer Douglas Benefield, but someone walked by her carrying a box. This witness before the court, Your Honor, sought a waiver so that he could speak with Dr. Russell. He got the waiver and he spoke with Dr. Russell. And Dr. Russell told him, and he admitted in his deposition to me, that she told him that Douglas Benefield was increasingly rough and would body check Ashley Benefield with a box, that he would slam it against her, and that it happened on the day of the shooting. And what is in those affidavits, both the actual and the proposed, is not that at all. When a detective comes to the court with a proposed warrant, it's not unusual that the court might ask some questions. And in this instance, if the court saw in the affidavit that it was Douglas Benefield who slammed Ashley Benefield with a cardboard box, the court might ask, being a student street smart, a question such as, what was the relationship between these two? Are they siblings or are they husband and wife? And when told they are husband and wife, Your Honor might say, well, is there a history of domestic violence here? And if the answer to that was yes, then the court might say, could this be a self-defense situation? The point being that the detective might have left without that warrant being signed.
Ooh.
I think this is clearly in contradiction to what he's testified to about a fair and objective
That's not good.
investigation that went on for several weeks before he submits this actual warrant.
I think everyone's panicking now.
So I propose to ask him about his actual
Okay.
warrant and then go back and go over the two proposed warrants to show what he left out and ask him why he
Fine.
left
We
it
know.
out.
We know.
And if he did not think that relevant to a judge that he was submitting the
I
statement.
wish you
under
just
oath
stop
to.
talking. Stop speaking. Shh. It's all good, mate. You got your point across. Stop
to
speaking.
prove or disprove what material fact, how is this material?
That this was anything but a fair investigation and a diligent investigation in direct contradiction to what he has told us here today. And just so the court knows, this is not my only point. I have coming behind it even stronger.
All right, final thoughts?
Judge, to be perfectly honest, I have no idea what we're talking about. The witness was not asked anything that was inconsistent with anything he said before. If the defense wants to try to disprove that it was a thorough and accurate investigation, then the defense can put on evidence in their own case. I don't think bringing in extrinsic evidence, I don't think the evidence is appropriate evidence to use for that purpose anyway. But even if it were allowed in, I don't know that you could do this extrinsic evidence at this point to impeach him for, I said I did a thorough job, but no, you didn't. I'm just a little confused by that. So I would object to any of this coming in at this moment. I'm sorry, I just don't know what rule of evidence we're proceeding under.
goes directly to bias of this witness who testified on direct. I didn't ask the question. The prosecutor asked the question, why did it take so long for you to get this warrant? Because we wanted to do a fair and objective investigation. That was what he testified to. And I am going to show with his own statements that that was not the case. It surely goes directly to this witness's bias and motive. And I have additional very strong evidence, Your Honor, to support that as well.
All right, well, whenever I start doing an analysis of these kind of arguments, what I want to hear is, well, what are you trying to do? Because that informs me to which folder to go to open up to see what's the predicate that needs to be laid and then what's the procedure for doing something. I don't see this as impeachment by prior inconsistent statement. Because I don't think, yes, he said I did a thorough job, but I don't think that is
fair
necessarily then opens the door to, well, why did you put a comma here and not here? And I'm being a bit melodramatic on that point, but because as I look at some of the highlights on the papers you've handed up, I mean, it's really a simple matter of just reordering some of the words. Now on the issue of the Dr. Russell, I see we're in the 2:06 p.m. email, Dr. Russell is mentioned.
Correct.
In the 3:37 email, Dr. Russell's name is now a witness.
Correct.
And I'm trying to look amongst all the talking at the actual arrest warrant that was submitted. It looks like it was attested to November 4th of 2020.
Yes.
I'm not seeing the incident with the.
I can show the court.
Ooh, this is going to go around in circles.
Yes.
I think, Judge, what distinguishes it from something that's inadvertent clearly is not only is Douglas Benefield now removed from the actual warrant as being the one who scraped Ashley Benefield with the box, but now there is the statement that that whoever this person was inadvertently scratched her with the box. And that is in direct contradiction to what this witness was told prior to him filing that arrest warrant. He asked for a waiver, which was given to him so he could interview several psychologists. He went and interviewed Dr. Russell. He acknowledged in deposition to me that Dr. Russell told him it was Doug Benefield and that he was becoming increasingly objective on that date by slamming a cardboard box into Ashley Benefield as he passed her in the hallway. And it was on the day of the incident, not the day before.
Right. But that testimony itself, you're just introducing that's what he was told, not for the truth of that's what happened.
Correct.
Okay, because that would be how many layers of hearsay? Three or four?
No. Look, I'm trying to show what he knew. Because he's the one who filed the affidavit, Your Honor.
Yeah, so I'll allow it for the very limited purposes of the fact that if you think that this shows that, and you're going to link this up, that he didn't do a thorough investigation, okay, we'll
Trust
see.
I will link it
But,
up.
I mean,
I'll link it up.
yeah, I mean, I don't know about you guys, but when I write an order, there might be 4 versions of it as I go through.
Well, Judge, at the risk of embarrassing the court, as far as Your Honor's authorship of orders, I have never seen an order like the order that the court wrote for the motion to compel.
Well, that could be taken 2 ways, couldn't it?
I've never seen a better order, Your Honor, or more thorough.
Enough for platitudes. All right.
I would just like to object to him using emails between he and I discussing probable cause as some form of I don't understand.
Ms. O'Donnell, I'm not quite sure yet either, but we spent a lot of time on this.
Yes.
I want to keep plowing through. I think I'll be able to figure it out when we get to the end of this. I'm pretty sure I'll be able to figure it out and where this fits in, and I will put it in its proper place and give it its proper weight. All right.
Thank you, Judge. And just for the record, I have no intention of involving Ms. O'Donnell in this. It's
Yeah,
going
if
to
you
be-
call her as a witness, we got a problem.
It's going to be limited strictly to the.
Fair play, Judge.
You can, but that's a monkey wrench.
We're not going down that.
All right.
She's been very professional.
Yes, I'm sorry. I apologize. Yes, sir. He was standing at the door waiting on me.
Jack.
Yeah, we'll allow it. I tell you what, though, let's not plow this earth too many times. Let's plow it, make your points,
And move on.
get in and get out.
And I think you'll find I
All
will
right.
do
Thank you.
exactly that.
All right, so go ahead and take your seat. You're still under oath.
Yes, sir.
As you're approaching your seat, anybody talk with you about your testimony or discuss anything with you?
Yes, sir.
All right, sir, have a seat. For your purposes, from where you left off, I have overruled the state's objection. Mr. Taylor has some questions for you.
Sure.
All right, Detective Warren, I'm going to put your actual warrant up on the screen, the affidavit. You recognize it, no?
Yes, sir.
Okay. Are you able to see it?
It's a little blurry.
Okay.
Oh, Carol. Yes. Thank you.
Let me give you this actual copy.
Okay.
So that'll assist you. Now, this was the affidavit that you took to the judge, correct?
Yes, sir.
All right. So I've highlighted on that affidavit in that particular paragraph that you see, and I have a couple of things boxed in red, correct?
Yes.
All right. I want to ask you about them. Does it say that upon further investigation, hold on a second.
It's not me breathing. Someone's breathing so heavy. It might be him.
All right. Does it say, Detective, in the third sentence of the top paragraph, upon further investigation, a witness explained that Ashley had obtained the scratch on her right side the day before the shooting when she was inadvertently scratched when someone walked by her carrying a box?
So in the fourth sentence, I do see that it says that, yes.
All right. Now, I'm going to pass to you a document and ask you if you recognize it.
Appears to be an email from myself.
Don't tell me what it is. I'm just going to ask you some
Sure.
questions.
Okay.
Does that document contain a proposed affidavit that was written by you?
There is an attachment to it. I mean, I can't say indefinitely that's the same one that was sent with it, but there is an attachment to it.
All right. Now, that document was sent on November 2nd, 2020 at 2:06 p.m. in the afternoon, correct?
According to the email you provided me with, yes, sir.
All right. And if you would turn to the proposed affidavit that's attached to that document that I just handed you,
Okay.
not the actual warrant,
Yeah, correct.
the email of,
The alleged attachment, yes, sir.
yeah. All right. So if you would tell me, instead of it saying now, a witness explained, is in that proposed affidavit, does it say Barbara Russell?
Oh, I'm sorry. Yes. So on the second page, we conduct an interview with Barbara Russell.
Okay. Now, Barbara Russell, her name has been removed from the actual affidavit, has it not?
Yes.
All right. Does it also then say that Douglas Benefield scraped Ashley Benefield with a box?
It does.
Okay. And going back to your actual warrant, does it say Douglas Benefield in your actual warrant?
No, it says someone,
Someone. Okay.
which could mean Douglas Benefield.
All right. And does it also say in your actual warrant that that someone who scratched Ashley Benefield with a box did so inadvertently?
While walking by. Yes.
Now, do you remember, as part of your investigation, you obtained a waiver for you to be able to go speak with Dr. Russell?
That's correct.
And that included also a waiver for Dr. Quintal.
Yes.
All right. Is it not a fact that you admitted to me that in your conversation with Dr. Russell, before you filed this actual affidavit to your warrant, that she told you that Douglas Benefield had become increasingly rough and would body check Ashley Benefield with a box?
I think those were your words.
And did you not agree to them?
I'd have to go back and listen to the interview. I apologize, sir.
Did you prepare to come here today to testify?
I did, sir.
You chose not to listen to it?
Objection.
Sustained.
Do you recall being asked the following question on page 23, line 14? This is your deposition of May 16th, correct?
I don't know. I don't have a copy in front of me, sir.
May I approach the witness, Your Honor?
Yes.
May 16th of 23. Okay.
All right. You recall being asked the following question. All right, and does it say on there, starting on line 11, so she said, this is Dr. Russell, so she said he had become increasingly rough, like he'd pick up a box to move it, pass her in the hallway, body check her. Your answer, that's what it says. Do you want to see it?
No.
All right. Then the next question, all right, do you recall her making that statement to you? Your answer, vaguely. You recall that?
Yeah, I still vaguely remember that.
Can I just ask for verification of what you were referring to with the first question? The first question was, you said this excerpt says, what was the excerpt that you were looking at?
That Dr. Russell had, may I respond?
Yeah, you're going to have to, because I don't know what we're talking about either.
The excerpt was that Dr. Russell had told the witness that Douglas Benefield had intentionally slammed the cardboard box.
Excerpt from what? Excerpted from.
From Dr. Russell's statement that this witness took. I was questioning him about the statement that he took from Dr. Russell. And I asked him, is it not a fact that this is what Dr. Russell told you? And that was the answer that he gave.
And this is where I was concerned. We're now impeaching with a prior inconsistent statement, conceivably. Statements that they were made in one version, but not the other version, and left out of another version, or
Right.
changed in another version. And you're impeaching with a statement from, an out-of-court statement from this witness received from a doctor who I haven't heard from, that was made to her presumably by the defendant.
No.
So we're just
Yes.
getting so far afield. And this is where I was saying, make your point and get out, because I've tried to give you that wide berth, but,
I'm on my way out, Judge.
okay,
All right.
all right. I get the point you're trying to make.
Yep.
Your
Okay.
point is, this witness has made multiple prior different statements, spoke with the state, changed it again, left out some, what you believe to be material details. I get it.
Okay.
The message is clearly received, if that's the point you're trying to make.
Thank you.
I just believe there's going to be numerous things like we're dealing with right now with this cross-examination.
Let's see how I do, Your Honor.
Okay.
All right. When you bring an arrest warrant to a judge, are you ever asked questions before it's signed?
Excuse me. What kind of questions are you referring to and by whom?
Have you ever been asked questions by a judge about a warrant that you have brought for signature?
Sir, I've submitted numerous warrants. Most of the time we don't talk to the judge.
You've never been questioned by a judge,
Most of the time we don't. Most of the time it's submitted via e-warrants, which is an electronic system.
and it's never happened to you, is your testimony.
Oh, I'm not going to say I've never talked to a judge. I just don't recall an incident off the top of my head.
All right. Let's talk about the wounds to Douglas Benefield and your perception of how they occurred. You stated, did you not, in your affidavit, that based upon the entrance wounds to Douglas Benefield, it does not appear that he was facing Ashley Benefield when she began shooting.
Objection.
Sustained.
Did you draw any conclusion as to whether or not Douglas Benefield was facing Ashley Benefield when he was shot?
Do you want me to read the warrant?
No?
No, so this is
Okay.
just testimony.
Just
we're
answer the
looking for.
question.
So yes, based on my observations and the work of the team that was assigned to work this case, it appeared that he was not facing her at that time.
And you know that the medical examiner said that he was.
I don't know what the medical examiner said, sir. I wasn't in here.
Oh, you've never seen the medical examiner's report?
Sustained.
I have seen the medical
No,
examiner's.
I sustained it.
Sorry.
It's improper impeachment to impeach this witness with a statement of an out-of-court statement of another witness.
Did you contact the medical examiner's office before you secured and drafted the final version of this warrant?
No, I did not. A detective would have been present at the autopsy, though.
Do you dispute now, as you sit here today, that Mr. Benefield was facing Ashley Benefield when he was shot?
Oh,
Relevance of his opinion.
Well, I think he's made the one conclusion. I think he could be asked, do you have the same conclusion today? So overruled.
Thank you.
I don't dispute anything the doctor said. He's the ultimate person that would give you that answer.
All right. Now, you also concluded that the wound to the right leg was from the outside of the leg to the inside. Is that correct?
Objection, relevance, and his opinion.
Again, I don't recall ever hearing him testify to that fact. So I don't know where that's coming from. I have not heard this from his mouth.
Did you reach a conclusion as to the direction of the gunshot to the deceased's right leg?
Objection, relevance of his interpretation of the direction of that wound.
I
The state is the one that filed the charge, not the detective, so.
I appreciate it. Overruled. If you can answer.
Sure.
I'm sorry, can you repeat the question?
Did you reach a conclusion, Detective Warren, as to the gunshot wound to the deceased's right leg?
Okay.
Okay, yes, you
As
reached.
to the direction,
Yes,
well, like I said, I would defer to the doctor, to be honest with you. I think he has the best opinion on that.
I understand and I appreciate that, but I'm interested in what your conclusion was.
So based on my observations, I wasn't there when he was there and I never saw him in person, would be that the right side of his body was facing Mrs. Benefield.
That's not the question I asked you, Detective. Did you not understand it?
Apparently not. Can you repeat it, sir?
Okay. So my question to you is, did you reach a conclusion as to the gunshot wound to Mr. Benefield's right leg?
Based on what I saw and everything at the scene, I believe that his right side was facing her. So that would have been what was struck first.
Did you state that the entry to the leg wound was on the outside of the knee and the exit was on the inside?
I could refer back to the warrant if you'd like, sir.
Please. If that helps refresh your recollection?
Sustained. Well, if he's refreshing recollection, that's a different issue.
Yes.
But
Refer to your warrant, Detective, see if that refreshes your recollection.
Jesus. I have to get. Oh, I don't know what to think now. What's going on?
So in my affidavit for the warrant, if one of the rounds entered the outside of the right leg and exited the inside of the right leg. That was based on what I was observing.
And as you sit here today, is that still your position that the entry wound was on the outside of the right knee and the exit wound was on the inside as opposed to it being reversed?
Based on my training experience, what I observed, sure. But like I said, I would always defer to the doctor. I would never argue with a medical expert.
I'm a bit lost now.
So I would assume then you would defer to the doctor as well as it relates to the proposed wound to the arm.
Absolutely.
All right. So you got wrong. One, whether or not Mr. Benefield was facing Ashley Benefield when he was shot, correct?
sustained and
All right. Your conclusion was inaccurate.
sustained.
All right, moving on.
What the fuck? What's going on?
You told us that you observed Miss Benefield that night, and you did not see any signs of domestic violence, struggle, or things of that nature, such as torn clothing.
That's accurate.
Okay. And is that, in your experience, always the case with domestic disputes?
No, not always.
And you're aware that the shirt that you observed on Miss Benefield that night, where it came from?
I'm sorry, which shirt are you referring to?
You said that you did not observe any torn clothing on Miss Benefield that night.
I did not.
Like her shirt was not torn, her shirt wasn't torn.
I didn't see anything, no.
Okay. Where did the shirt that you remarked that you didn't see torn come from? Do you know?
I have no idea where she purchased the shirt or where she got it, sir.
Isn't it a fact, Detective? Now, you're the lead detective, correct?
Sure.
That shirt was brought to her by another deputy while she was sitting in a squad car, was it not? That would be Deputy
I wasn't at the
Paul.
scene, sir.
But wouldn't that be something you'd be expected?
I don't know if it is or not. Let him finish the question.
Wouldn't that be something as the lead detective you would be expected to know before you make the statement that you didn't observe any torn clothing, which is inconsistent with domestic violence?
No, and I think if you actually play it back, I already testified to the fact that she was wearing a sports bra.
All right. I want to ask you a couple of questions about the home. You drafted a search warrant for the house, correct?
That's accurate.
All right. And you drafted that search warrant pretty much immediately based on your experience of knowing that you wanted to get into the house to conduct the investigation.
I drafted that search warrant based on the other detectives on scene advising there was probable cause to assume that a potential homicide occurred inside. Yes, sir.
Okay. Now, I'm glad you referred it that way, because isn't it a fact that that warrant that you were drafting less than 75 minutes after the shooting, isn't it a fact that you didn't describe it as a homicide, you described it as a murder? Did you not?
I'd have to look at the warrant again, but that's
I'll be
possible.
happy
Sure.
to show it to you.
Bloody hell.
Yeah.
Understand the difference between
So what's the relevance?
I think the relevance is to show that this detective had already reached a conclusion that this was a crime rather than a homicide, despite his testimony that he wanted to do a fair and objective investigation over the course of an extended period of time, and that he was referring to it and calling it a murder within approximately 75 minutes following the incident.
All right.
He'd already made his mind up.
Detective Warren, can you step out in the hallway? It's easier if you step, we can send you out.
That's not a
It's easier
problem,
than
sir.
having them approach.
Not a problem, sir.
The rules have been invoked. Don't discuss your testimony. Don't let anybody talk to you about your testimony.
Yes, sir. Thank you.
Bloody hell.
All right. So I don't think I have the search warrant, unless it was one of the attachments. I don't recall seeing it.
I'll give the court a copy.
Well, let me ask you this. So the point you're making is that instead of using the word homicide as the crime that's being investigated, the detective used murder.
Yes, and
So what statute would you have proposed that he should have used? Because as we know, a search warrant, what's the point of a search warrant? That a crime's occurred or is occurring or has occurred, and that there's probable cause or a reasonable probability that the fruits of that crime or the evidence of that crime is going to be found within the place to be searched.
yes,
So a search warrant will list a crime or crimes that have alleged to have been committed. So what I'm saying is, what is your argument that he should have put as opposed to murder with 78204?
Yes, sir.
Yeah.
As opposed to 78204?
my argument is that every single member of the Manatee County Sheriff's Office but him described this as a homicide, including the medical examiner, rather than a murder. But that's not enough. This detective, in his deposition to me, believe it or not, under oath, said and represented that every homicide is a murder, and anybody who shoots and kills somebody is a murderer. That is his perception of
Hey,
murder.
Toxic.
As opposed to an objective evaluation, what I am tying in is that within 75 minutes after this incident occurred, this detective had already decided that my client had committed murder. That's what I want to bring out.
All right. I appreciate all that. I'm happy to receive that. I'm going to respectfully, as you said today several times, suggest that there is a much more direct route to get where you want to go. There's no jury here, so, impeach, but,
Okay,
okay, so I think you
I got
can
it.
get there. I think we can be a little bit more direct about it.
yes,
Um,
I understand.
Yeah.
I'll go right to it.
I think, you want to say, hey, you said murder in your
Right.
search warrant. Yes, I did.
Yep.
That
I'll
was
be back.
within 75 minutes of being called out. Yes, it was. And that you can make all those arguments you want to make about how that was biased and his mind was made up and it was predisposed, how this was going to go. And I'll receive all of that.
Understood.
Okay. There was one other issue you were asking about.
Judge, before we move on from that, just so I can understand from defense counsel, is, because I'm looking at the actual search warrant and the only time it refers to murder is where it says the statute number. Is that the only instance in which he's referring, or is there some other? I couldn't find another one. I just want to make sure before we continue that we understand.
I assume that's the issue.
Oh,
Right.
Thank you. I just want to make sure.
All right.
I think we can bring him in.
Yes, he's on his way. All right, Detective Warren, take your seat back.
Yes, sir.
Did anybody discuss your testimony with you, approach you, try and talk with you?
No, sir.
All right. So I have sustained the state's last objection. Mr. Taylor.
So Detective, you described the incident that you were investigating within 75 minutes of it happening as a murder.
In the search warrant?
Yes.
Sure.
All right.
I think all of our search warrants actually are for the same thing when we're
did the
investigating
same-
murders.
You did the same thing for 2 other search warrants.
Yes, sir. That's what our unit investigates are murders.
Now, did you tell me under oath that every homicide is a murder?
I believe I might have misspoke when I said that, but so basically the intentional killing, unlawful and intentional killing of a human being is a murder, yes.
Did you tell me, just to make sure that it wasn't a mistake, did you not tell me that anyone who kills is a murderer?
Well, there's differences in whether it being
Is the
justified or
answer to
not.
my question yes?
Objection, is this impeachment? And is
I'm going to sustain.
Thank you.
Again, I think when we're impeaching with a prior inconsistent statement, we don't lead with the out-of-court statement that might be inconsistent. I would need to hear the testimony here today, what the answer is, and then I can determine if the prior statement is inconsistent. So I'll sustain.
Do you remember me asking you at the deposition the following question? On page 11, line 20, you could have a homicide that's,
Objection and proper impeachment.
I'm going to sustain. I need the answer. I need an answer here in open court, and then we
Okay.
can discuss whether that's a prior inconsistent statement.
are all homicides murders?
The unlawful killing of a human being is a murder. Yes, sir. There are some cases where it may be justified.
It may also be excusable.
Sure.
Is everybody then who kills a murderer?
And that's a matter of opinion, I guess. But I mean, by the definition, a murder is the unlawful killing of a human being.
Is it your statement that anyone who kills is a murderer?
Objection, asked and answered.
Sustained.
Would you be surprised to learn that you were the only one
Objection.
Let the question finish, please. Go ahead,
in
sir.
the Manatee County Sheriff's Office throughout this case who designated it as a murder as opposed to a homicide?
Don't answer. Sustained.
Another interview that you did was of Dr. Quintal, was it not?
I did an interview with Dr. Quintal, yes.
And you conducted that interview pursuant to a waiver that was given to you by Ashley Benefield so that Dr. Quintal could share with you the health information that he derived from interviewing Ashley Benefield, correct?
Yes, sir. We were trying to gain an idea of what their relationship was like.
Did you learn during your interview with Dr. Quintal that Ashley Benefield was afraid of Douglas Benefield?
He may have made some statements indicating that she made some, or he had some feeling about that.
Did you learn that she was scared of violence from him?
Like I said, he said a lot of things. He also said he didn't understand why Douglas was with her.
Did you learn that Dr. Quintal told you that Douglas Benefield was a controller,
Objection, this is.
Sustained.
not offered for the truth, Your Honor, offered for what this witness learned and knew during the course of his investigation?
And that's
Well, what does that have to do with, I'm not understanding what the relevance of that is. That a doctor told this witness that the defendant said the victim was
Not the defendant,
controlling.
Your Honor, that Douglas Benefield, the victim,
Right,
was a controller.
right. But the doctor would have heard that from the defendant?
Yes,
All
but
right.
it's also the doctor's opinion. He was giving this detective his opinion of Douglas Benefield. And he was describing Douglas Benefield to this detective. And there's a reason why I'm asking. I'm going to follow up with a question.
It sounds like you're offering that for the truth.
No, sir. I think you'll see why I want to show that this witness was aware of this.
Okay, I don't know, but we're gonna see.
I will tie it up for the
Okay.
court very quickly. Do you recall Dr. Quintal telling you that he believed that Douglas Benefield was a fake who used God as a pretense?
I remember the topic of God did come up. I don't remember, like I said, every word that he said verbatim, which is why it would have been tape recorded.
And you have that recording, do you not?
You should have it as well. Yes, sir.
Yeah. And do you recall Dr. Quintel telling you that Douglas Benefield?
Yeah, listen, I'm really, sir, not understanding. I mean, what is the point of all of this?
Next question. If Douglas Benefield had a violent background, is that something that you would want to know?
Sure.
Is that something that would be significant for purposes of your investigation?
One of the things that we looked at was he violent with her? That's why we went through all of the reports. We wanted to know the background because, as I stated earlier, we wanted to do a thorough and accurate investigation before anybody was charged with a crime.
Would you tell His Honor, Judge White, whether you ever did a background investigation to determine whether or not Douglas Benefield was violent?
We did searches based on what was available through the Manatee County Records database. And I believe we also got some information from Charleston or somewhere up, one of those places up there where there were some allegations, but that was it.
Do you remember me asking you this question at your deposition?
Well, I don't know if it is yet. It might be inconsistent with the statement that was just made about the investigation that was done, but I don't know.
I asked the question. Do you remember being asked the following question on page 84, line 16? When you investigate a case like this, you told me that you don't recall whether or not you did a background on Douglas Benefield himself. Your answer was, I don't recall doing it myself. No.
You're talking about a background, meaning the criminal history. I don't recall doing a criminal history on Douglas Benefield to see if he was a convicted felon, but a background check. It's actually listed, I believe, in some of these other reports where we looked up Manatee County computer records databases and pulled those reports.
So is it your position?
This is pointless now.
That only convicted felons can have violent backgrounds?
Come on.
I overruled.
Thank you.
If you repeat the question.
Is that what you're telling us?
Can you repeat the question?
Yes.
Thank
The
you.
question was, are you telling us that only convicted felons can have violent backgrounds?
No, but there is a difference between doing a computer record check through our personal database and doing a criminal history check through NCIC, FCIC.
So let me ask you the question again. Perhaps you didn't understand it.
Perhaps.
Did you ever do
Sustain.
Did you ever do a background investigation to determine what you've told us you would want to know, whether or not Douglas Benefield was prone to violence?
Like I told you, sir, we did searches to find out what information was available. You can change the definition of background check all you want to. Yes, we did our due diligence.
Have you read, by the way, have you had an opportunity to read or discuss the stand your ground motion we filed with the prosecution?
I did, but it was months back, I'm sure.
There's a representation that Douglas Benefield grabbed Mrs. Benefield by the left hand to prevent her from leaving. Do you recall that?
No, not off the top of my head, sir.
All right. You, as part of your duties and responsibilities as the lead detective on the case, you requested swabs, did you not, of various parts of Miss Benefield?
We did.
All right. And that would include her left hand, would it not?
It would have included the areas that we were explained by her attorneys to pay the most attention to.
Did it include her left hand, detective?
You would have to probably direct that towards the crime scene tech that collected the swabs.
Well, how about if I use your report?
Okay.
Objection, Judge.
Yeah, if he's just relating what someone else said or did,
No,
I'm going to sustain.
I'm asking if he requested that swabs be taken of her left hand.
Okay,
That was the
that
question.
question can be
Yeah.
asked.
That was the question. Did you request swabs be taken of Miss Benefield's left hand?
I requested the swabs be taken of her arms, legs, hands, and neck.
Okay.
Good. Fine. Oh, my days.
As part of your duties and responsibilities as a lead detective, did you ever get the laboratory results of those swabs from FDLE, Florida Department of Law Enforcement?
Was it FDLE or DNA Labs International?
Actually, I believe it was DNA Labs International. I stand corrected.
Okay.
Did you get the results back?
Yes.
Did you learn that out of all the people in the world,
Objection to asking this witness about the results of the DNA.
Again, you can ask your question and then we'll have the objection. Again, I make this ruling because there's no jury here.
I know,
So if I sustain it, I sustain it.
but he's testifying by asking the question.
did you learn that of all the people in the world, only 2 people could not be ruled out for having left DNA on Miss Benefield's left hand? John Sant, the neighbor, and Douglas Benefield.
I would, I'm sorry.
No, do you have an objection?
Yes, that calls for hearsay and I think
Sustained.
misrepresentation of the report.
I haven't seen the report, but it's hearsay. Absolutely.
All right, Detective, I have a few questions now I'd like to ask you about some areas that we discussed previously under oath. I had asked you at the deposition various things about Douglas Benefield. For example, in
Objection, is this impeachment?
Sorry, I have to pause it. It's just getting. You both said it. Toxic said it, and Sarah said it. It's just like, what are we doing? Come on, guys. I mean, is this what they start like? All these hearings are like. I'm just a bit like, right. So you want to find out these things? Why can't you just ask the things and let's go? I don't know where I don't know where he's going anymore. The officer's answered all the questions so far. We're just going around in circles. It's quite annoying. But also, like, I get why the prosecution have to object every time. But like, prosecutor, if the judge tells you one more time to let him finish the question first, I'm gonna go mad. She just jumps up and says objection before you even finish the question. I don't know. She's right to object. Don't get me wrong, but let him finish the bloody thing. You do, but I don't think he has much to work with in this one. Yeah. Yeah, I mean, he's going for everything here. He's all working overtime, but he's clutching at so many straws everywhere. I'm not like having a pop at him. It's just more like the court seems to be disorganized now. I don't know what's going on. I just needed like a couple of minutes just to break there because he was getting a little bit hostile and whew, sometimes you just need to take a breath and just relax. Lefty, how are you doing, sir? Hope you're well. Oh, all the nerds are here. Oh, right. I'll start back again now. Amy, it will be interesting to see how he does, how this attorney does. Yeah, you're right. He probably hasn't got anything to play with. This. I just wish he's more direct, straight to the point. But obviously he can't be. Maybe he's got nothing. So he's clutching straws. I know that much.
I don't know.
I gotta say the question.
Yeah. So
Bloody hell, Spider Girl wakes up as soon as Lefty comes
So the
in.
deposition is an out-of-court statement, which is the first phase of hearsay. I don't know why it's going to be offered, but I don't know if you're refreshing a recollection, which is done a different way. I don't know if you're impeaching. If you're impeaching with a prior consistent statement, all I can say is, again, I need a statement here in open court, and then we can figure out if that prior statement was inconsistent.
Here comes the statement. Detective, do you have an opinion? How would you describe Mr. Benefield admitting that he shot a gun in the house, in the kitchen, to intimidate Miss Benefield to stop speaking?
Objection.
Sustained.
What?
How would you characterize such?
Objection.
Hold on, I didn't hear the rest of it.
Yeah, I'm just asking him how he would characterize such an act of shooting a gun in the kitchen to intimidate someone from speaking any further.
You want this
Objection.
witness's opinion about how he would characterize without any frame of reference. I mean, what do you mean?
Okay. Detective, were you aware that there was an allegation that Douglas Benefield had shot a gun in the kitchen ceiling of their home to stop Mrs. Benefield from speaking any further?
I was aware, or I had heard that there was an incident allegedly that a firearm was discharged in the residence into the ceiling.
And would you describe that as a violent act?
I guess it all depends on the purpose and how it occurred.
True.
Such as?
Objection as to his opinion.
Yeah, I'm going to sustain on and we're getting into a collateral matter, how this witness would characterize an act that he did investigate, he wasn't there for, he's heard about
All right.
through some unknown source. So, no, what his opinion of that, I'm going to find is irrelevant.
Were you aware during the course of your investigation, detective, that there was an allegation that Mr. Benefield would punch holes in the drywall of their home?
I believe that I had heard something like that, but I don't recall where that was from.
Were you aware that there was an allegation that Mr. Benefield had beaten his first wife up on their honeymoon?
Objection, Judge, what is it? It is irrelevant.
I don't know,
Detective may or
toxic.
may not have known about his past.
Well, actually, Judge, this detective has testified that whether Mr. Benefield had a violent background is something he would want to know, that it would be significant to his investigation.
Right. You know, I'm not taking any of this for the truth of the matter asserted.
I understand.
Right, all you're asking is, did you hear this? It doesn't prove that those things happened.
I understand that.
So I'm not
Okay.
sure why we're asking them this problem.
And that would be the second question is, so what's the relevance of whether he heard that the decedent may have been violent towards, I don't, would you say a first wife? I don't even know who that is. I don't know when they were married, how long they
Yes.
were married. I don't know the
First
nature of their
wife, Renee.
relationship. So I'm going to sustain as irrelevant.
Okay. You are aware, are you not, of an incident where Mr. Benefield was seen by a neighbor at night standing in her yard?
Sorry. Yeah, actually, we discussed that during the deposition. I remember because I had some questions about it myself.
There's a police report that accompanied it. Have you
Yeah.
reviewed it?
I did it one time, and I believe that the witness said that there was a person standing there. And I asked you how we got him identified because I guess they identified him by his voice, is what you told me, which I found odd because why would you sneak around and then talk? Kind of, you know.
Did you review that witness's deposition?
I did not.
It's Exhibit 5 to our standing ground.
I don't have access to those, so.
Have you ever placed a tracker on anybody's car?
Irrelevant.
I'll overrule.
Have you ever placed a tracker on anybody's car without the appropriate legal authority?
No, but I've done it with the proper legal authority several times.
I want to lastly ask you about some photographs of Miss Benefield. There were 2 sets of photographs taken, you testified to, correct?
Yes, sir.
Some were on the evening of the incident, and then there was a set that were taken a few days later.
Yes, sir. That's accurate.
So to cut to the quick, if we can, and not test what has up to this point been the judge's considerable patience,
Bloody hell.
the scratches that were preserved in those photographs on Miss Benefield on the night of the incident, you saw them, did you not?
In the photographs later, yes.
Yeah, and they show as red and fresh, do they not?
They appear to be red, yes. I
Okay.
can't tell you how fresh they are. I'm not a wound expert.
Okay, well, they weren't scabbed.
Like I said, I didn't. I saw a photograph later on.
Let me show you the photos.
Sure.
No, it wasn't scabbed. I even know it wasn't scabbed.
Thank you, sir.
I've asked you 4 photographs that have been previously considered. Do they depict scratches on Miss Benefield on the evening of this incident?
They appear to.
Okay, and do the scratches appear fresh?
I don't think necessarily the one up under the sports bra appears.
Are
to be.
they, what color are they? Are they pink?
Like I said, I'm not a color palette expert, but I would go with sure. They could be pink or red.
Okay, are any of them scabbed?
It's kind of hard to tell because they're so minute.
Do you see any scab?
No, and I don't actually even see an open wound on this one that would scab over. So
Okay, let me show you the photographs a few days later.
okay.
In the trial, these two are going to go at it so hard.
Why are these not marked? Yeah, if you're going to use photos, you either need to mark the ones you're using or use the ones that have already been admitted. Because we need to have a record of what
Yeah,
you're
I
showing
agree.
the witness.
I agree. I mean, this is going to be a wild trial, I think. This lawyer if he's going to be like this, he's going to really annoy the jury, I think, though. But I don't think he's doing a bad job either. But these two are going to go
I'm
at
fine
it.
if it's just defense 1, 2, 3, 4, 5, 6. You don't have to use letters or anything. Okay. All right, we're gonna call these defense 1 through 6.
Very good, Your Honor.
My, Delilah. Come on. Yeah, she could have inflicted on herself. That's more than plausible and probably more than likely. And one of them was by a box. So we know that. For the rest of them.
Detective, I previously showed you defense exhibits 1 through 4, correct?
Yes, sir, that's correct. There you go.
Now
Could I just see them? I'm sorry.
Now I'm going to show you defendant's exhibits 5 and 6.
Thank you.
I'm going to ask you if those are photographs that were taken several days later.
You would have to talk to the crime scene tech about that for proper identification, but I believe so. Yes, sir.
And is the color of those scratches different than the color of the scratches in the photographs that were 1 through 4?
Well, the scratch that was on her hip, the red scratch that I said didn't have a scab, that's not even photographed in any of these, just so you know. It's actually gone.
Mhm.
Other than that small little minute thing you can barely see,
Yeah.
there does appear to be some scabbing, but it's very, like I said, very tiny.
Are you familiar with the concept of blading?
I am.
And tell us, educate us a little bit about what blading is in the sense of it being a defensive posture.
Are we talking about it in regards to law enforcement?
No.
Okay, well, I'm just, you know, I'm not a jujitsu expert or anything, so.
I understand. I'm talking about with respect to minimizing the area of your body that is exposed to potential gunfire.
Okay, I guess if you were trying to minimize the
Criminal
area exposed,
minds.
you would possibly turn your smallest side to it. Which would be your side? Sure.
Okay, otherwise known as blading.
If that's what you want to call it. Blading typically isn't a complete turn. It's more of a 45-degree angle or so.
Okay, again, to minimize the exposure.
Well, blading or interview stands, those types of things, blading is typically done like for our purposes. If I'm out interviewing a suspect, I'm going to blade my body and turn my gun sight away from them because honestly, that's more of a threat if they're looking at my gun while they're thinking about fighting me. I want to keep that away from. It also provides for balance.
Right. You want to make sure that they can't get the drop on you.
It's more of a safety thing than an offensive thing, at least in my opinion.
Yeah, to protect.
Like I said,
you.
I'm not an expert, so.
To protect you. As part of your investigation, you determined that the firearm that was used to shoot Mr. Benefield was owned by Ashley Benefield.
One of our detectives, I'm sure, did would have done that part of it. I don't recall doing that part myself.
All right, but you do recall it was lawfully owned by her.
As far as I'm aware, yes.
Yeah, and that she had a concealed weapons permit.
She may have. I don't remember if she did at that point, but it's possible.
I don't believe I have anything further, Your Honor.
Oh,
Thank you for your patience.
State, redirect. All right, can this witness be excused?
yes.
Can the witness be excused? Mr. Taylor, can the witness be excused?
Yes.
All right, Detective Warren, you're excused.
Thank you, sir.
So can you reach me those papers?
Yes, sir.
That was painful. Right, who's next?
Mr. Taylor, I think these are yours papers. And your paper clips. Yes, sir.
Right, it's not much law.
All right. State.
The next witness is going to be a little lengthy. You can take a 5-minute break.
Sure, absolutely.
Okay, 5-minute break.
It is 4:06. How about, 4:15, maybe a few minutes after 4:15?
Okay, sir.
All right, we'll see you then.
Oh, I know. Hardly anything went his way. Oh, she's nice. I'll be honest with you, she is. She's got best resting bitch face right now, but she is fucking nice, so I'll give her that. I think this shows us, though, how little the defense have got in this case.
Yeah, these are the text messages, which.
Correct, yes, sir.
we objected to because of relevance. We still believe them to be relevant, but as Your Honor has noted.
See that look? Oh, yeah, I know.
Relevance.
Judge, the relevance is the tenor of the relationship. This is all after she's made all of these allegations against the defendant.
But it's a sexy look, though, I'll be honest with you. Toxic.
She's telling people that she's afraid of the defendant or the victim, I'm sorry, and she's afraid for her child, but yet she's having these text conversations with him that clearly there doesn't appear to be any fear, and it helps set the tone for the relationship.
All right. There was also, I know relevance was now, but there was also the objection to hearsay, not as to obviously the text attributable to the defendant, right, or come in. But what about the argument that any text by was alleged to be Mr. Benefield hearsay?
I would have to know which text specifically, but like for instance, he says trucker on the way as the last text. So my argument for that would be statement of intent, that hearsay is allowed to come in if it's a statement of intent by a witness and the state is trying to show that the witness complied or acted in compliance with that statement. So that would be my response to that. The other ones of good morning, good night, those aren't offered for the truth of the matter.
All right. Yes, sir, Mr. Taylor. So there's your answers to your two objections. So anything else you want to put on the record, sir?
I don't believe so, Your Honor. I'm a lot more concerned with the next witness that I'd like to take up with the court.
All right. Well, there's some foreshadowing for you. Okay, I'm going to allow it. I'm going to overrule the objections to defense. States 45 is admitted, that being the text messages. I find them relevant solely for the purpose of the state's argument, and that's the only way that I'm going to take them, because that's why the state has said they're offering them, is just to show the nature and tenor of the communications and the relationship between the parties in the days leading up to the event. And as to hearsay, certainly any statements made by the defendant or attributable to the defendant as part of this text messaging would be admissible under the.
Toxic. All right. I'll be honest here, right? There must be some things that we disagree on or agree on, but we will definitely disagree on this one. I think she's very, very beautiful. I know what she's done, but my, she is sexy. Everything about her so sexy. It's gone past the 2-hour mark. Let's go. I can say whatever the fuck I want. I think she's gorgeous.
The rules. And as to the other ones,
Gorgeous.
again, I don't find that they're offered for the truth of the matter asserted. With the good night, the good morning. What do you need at Lowe's? You want to go to Panera? I'm taking it solely for the purposes that the state has said they're submitting it. So I will overrule on that.
I'm so limited though. I don't know why.
All right, sorry about that. I got my papers out of order.
Plain Jane. So I'll pause for a second. I think
All right, who is the next witness?
I press an ad. Plain Jane. I think she's out of this. Well, not out of this world, but I think she's very, 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 very attractive. I think she's probably the prettiest I've seen, as in covering trials and stuff. Just doing that for a second because I pressed the ad button. But
So if there's concerns, let's hear them now, I guess. If they're general concerns as opposed to discrete portions of his testimony.
I think this witness wants to get down the rabbit hole that we were hoping to avoid.
I agree. I don't think Jodi Arias
This
was.
is the detective,
No ways.
Judge White, that was assigned to the DCF cases and the allegations of abuse by Mrs. Benefield against Mr. Douglas Benefield. And I don't think it has any relevance whatsoever to the proceedings. I think that we're going to end up in a dispute as to what the conclusions were, that is to say, unfounded,
Oh, spiders on one.
as opposed to ridiculous or nonsense, that kind of thing. It's one thing when something is not proven by insufficient evidence. It's quite another thing when it is determined to be unfounded. I don't know that any of the DCF people who actually made the decisions are going to be present to be able to be cross-examined. And I think even if they were, I don't think that that's a road that we want to go down because, again, I don't think it has any relevance to the proceedings at all. Even if we give the state the benefit of their theory in creating motive and showing what they want to show, such as the text messages between parties that they were getting along, I don't know what the substance of the abuse allegations lends to that.
All right, let me just say this. That's where my mind is going, but I don't know anything about these allegations. I don't think it's in any of the paperwork.
I can tell you, Judge, my intention, and it's for the same reason that I entered Judge Moreland's oral order for the previous.
There we are,
I do
Spidey.
not intend to get into anything other than there was a complaint, who investigated, was it sexual abuse or physical abuse, and against who? And then was it investigated, and did this detective close the case? Or, file the case, or how did it work?
Let me get a little bit more. Oh, hold on. As you may have noticed, I'm pretty big on procedure. And so I go with proponent, and then I come back to the non-movement or non-proponent, and then I come back for rebuttal. So when I come to you, tell me everything you want to know, because I don't ping pong back and forth. But I have questions because I don't know anything about this. Who are the complaints against?
The complaints are the defendant making complaints of sexual and physical abuse against the victim,
Regarding what child?
the same child, Emerson.
Emerson. Because I've heard about an older child.
Yes.
And
we will
Emerson.
establish that.
All right, so these are complaints made by the defendant
Yes.
against the decedent
Yes.
regarding their natural
Their
child.
natural child who was a toddler at the time.
When were they made?
I have the dates. December 10th, 2019. March 21st, 2020. March 23rd, 2020. April 5th, 2020. And April 27th, 2020.
Oops, sorry. All right. So tell me, what is your theory as to why these tend to prove or disprove any material facts that I need to consider?
Well, to me, there are two issues. There's credibility, ultimately the credibility of the defendant, because we have to take the facts as known by her, or as at least as she's saying. So the credibility of the defendant is an issue. So some of these things that I'm getting into go towards the credibility or lack of credibility. These things also go to the motive for this, because the defendant attempted in court over and over and over to stop this communication with the child, and Judge Moreland stopped that. So she changed tack and then went to abuse against the child as opposed to supposed abuse against her. And she attempted for the abuse against the child. And she even makes comments to a witness that we're gonna have later on that nobody will help me, what am I gonna do? Nobody will listen to me, because these reports were not being filed by law enforcement. And then at the time, all of this is going on at the time they're inviting it in the text messages. So
All of what's going on?
these complaints are going on before the text messages where they're.
Yeah, I was going to say, because those are from the week before.
they're from the week
These are
before.
months before.
Yes, so these had already been made, I apologize, these had already been made at the time that there's talking like they are here. And her argument is, I just want to save my child, that's the only reason I'm around him, this is all gonna come out later on. And otherwise I would never be around him, nobody will listen to me, I have to move to Maryland to get a new family jurisdiction. So this goes into everyone, she had exhausted, in the state's opinion, every avenue that she could to keep this man away from child. And when she felt like no one else was going to do anything, this was the result.
All right. Anything else?
No.
All right. Now, sir.
So, Your Honor, you wear the robe. But all I can say is, as I tried to explain in my opening statement, the parameters of the stand your ground statute require the state to prove by clear and convincing evidence why the force used was not justified. I don't see how motive has anything to do with that. I also don't respectfully see how complaints about abuse have anything to do with that. And what I'm particularly concerned about, and the reason why I think it's going to be, to a great extent, a depletion of the court's time unnecessarily, is that this detective was not the one who received the complaints. That would have been DCF. So this detective, whatever he has to say, is going to the extent it's substantive, is going to be based on rank hearsay. That's number one. Number two, I'm concerned about this detective offering an opinion as to how the case was closed. Assuming the court were to allow it, I could understand if the state asks, and was the case closed? Yes, okay, next. On the other hand, I could not understand if the question is, how was the case closed? What was closed is unfounded. In other words, there was not a scintilla of truth to it. How am I going to cross-examine this detective based upon that conclusion, which was rendered by somebody else?
All right, so what I'm hearing is this detective, he's a CAC?
Yes.
All right, crimes against children. A complaint was made
Yes. To the sheriff's office.
by the defendant.
5 times. Yes.
Hold on. For each individual complaint.
Yes.
Complaint was made by the defendant on such and such a date against the decedent. Just a very broad category alleging some sort of abuse against their natural daughter. It was investigated and it was closed. Right? That's all you want.
Judge, I believe its effect on listener the same as Judge Moreland's order, the fact that it was closed unfounded. That is the part that has an effect on the defendant. I'm not offering it to prove that there was no evidence of it, just with the
And
defendant.
this is a weird thing, because I've heard that now, but I think the point is, what your point is, it was closed and no action was taken, whether it was unfounded, unsubstantiated, fanciful, improbable. I don't even know what I do know unsubstantiated, unfounded. No, I think those are the big ones. I'll allow that. I'll allow the fact it was closed with no action taken.
If I could just let him know.
Yeah, let him know,
I'm not sure.
and I'll prepare the curative instruction for the jury.
Okay.
But at the end of the day, I understand, and this is what I was saying earlier to the defense is, I understand the point you're trying to make. I get it. I know where you're going. No problem. I'm with you. I'm following you. The same as with Mr. Taylor. I just think there's a much more direct way to get there. All right. In fact, quite frankly, if that's all it's going to be, there could probably be a stipulation here, but that's all I'm going to allow. And then you can argue at the end, and you can argue at the end the opposite side. Okay. That she was absolutely privileged to make these complaints, and she must have had a good faith basis to do so, and so be it. There was no action taken.
Judge, I would rather call him.
That's fine. And I'm not, listen, I honestly, I just threw that out there. You know, I sometimes do things gratuitously. I shouldn't. So go ahead.
State Falls Detective Brian Moreland.
I'm pro to gratuitous musings.
Brian Moreland. This is confusing. Ooh, I might have the delivery.
Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth?
I hope I got delivery. Maybe not.
Oh, did you get a chance to go talk to him?
No, but I'll lead.
Okay. On that one issue, I'll probably allow a little bit of latitude on leading just to keep it clean. Hello, Detective. Hello. Sir, make yourself comfortable in that chair. Adjust that microphone up, down, left, right, however you need. Just a loud, clear voice. We should pick up everything. Thank you, sir.
Please state your name.
Detective Brian Moreland,
Where do you work?
Manatee County Sheriff's Office.
Okay. Are you in relation to Judge Moreland?
No, ma'am.
Okay. How long have you worked for Manatee County Sheriff's Office?
Since 2004.
What is your current position?
I'm a crimes against children detective
How long have you done that?
since 2011.
And what does a crimes against children detective investigate, just generally? What kinds of crimes?
We take general assignment, so any kind of abuse, neglect, death investigation, sexual abuse, things like that. Anything that happens to anybody under the age of 18 years.
Okay, so other children.
No delivery.
When you investigate.
No,
any
that's,
serious
Wednesday,
physical abuse or
Spidey.
Sexual abuse, do other agencies all work together with you?
Other entities do, yes, ma'am.
Entities, okay, and who are those entities?
Generally, child protection, the child protection team, which is here in Manatee County, and then what I would refer to as DCF or Child Protection Services.
Okay, so I just want to make clear, you're law enforcement, so you do investigations for criminal charges.
That's correct.
Okay, and if DCF is involved, they are not investigating for criminal charges, correct?
Correct.
Okay. So they have different goals, I guess
Yes.
is my point.
Their goal is the safety of the children involved.
And CPT is not a part of DCF, I just want to put that on the record.
No, ma'am.
Okay. When there's an allegation of abuse, what is the protocol? Who goes out to investigate first?
Generally, what happens in at least my criminal investigations is once the allegations are made, they'll go through the Florida Abuse Hotline. CPS would get involved, call for law enforcement. Generally, what happens is a uniformed law enforcement deputy goes out and takes the initial investigation. If further investigation is warranted, it'll make its way to our office and get assigned to a detective.
Okay, so, and during this process where there's an initial law enforcement officer, is there typically someone from DCF there? I think you said CPI.
CPI,
Okay, which is a part of DCF.
yes, child protection investigator.
Okay. So only when further investigation is needed do you get assigned?
Correct.
Were you in that position, the same position you're in now back in 2019?
Yes, ma'am.
Did you become familiar with someone named Ashley Benefield
Yes, ma'am.
and her child with Doug Benefield, Emerson?
Yes, ma'am.
Were you involved in investigating a series of allegations, starting back, I guess, in
No worries, toxic.
2017, but really in 19, I guess, is what I want to concentrate on.
Yes.
Okay. let's start with the first allegation that came in 2019, the date of December 2019.
Yes, ma'am.
Do you recall that
Yes.
allegation?
Mhm.
Okay. And without getting too much into the facts of it, what type of an allegation was it?
That was a sexual abuse allegation.
Sexual abuse allegation, and the allegation was made by
The reporting party was Ashley Benfield,
Ashley Benefield, and saying who was doing the abusing.
Doug Benfield.
And clearly you opened up a MSO case number on that.
It was opened by the uniform deputy.
Already open. Okay. So at this time, the uniformed deputy had already gone out, as well as the child protection investigator.
Yes, ma'am.
Do you know if she went to CPT that time?
In 2019, she was seen by Dr. Riley at CPT. Yes.
Okay. And CPT, that is a medical exam?
They perform two functions for us. In my criminal investigations, they do forensic interviews for us and also medical evaluations. Yes.
With respect to what we're talking about with Emerson, she was how old?
She was too young for
Too
a
young.
forensic interview. Yes.
How old was she? Like 2 or toddler?
Yes.
After this first complaint came in or allegation came in, did you investigate?
Yes, ma'am.
Did you speak with the parties or speak with Doug Benefield?
I did.
Okay. And did your conversation with him give you any concern?
No.
Okay.
Sustained.
And you eventually just closed that case with no charges, correct?
That's correct.
So I want to talk about the second, what I call the second report. Do you know what date that came in?
Are we referring to a 2020 report?
Yes. Yeah.
May I look at mine?
Yes. Go right ahead.
Hi, Wendy.
The report date on that was March 21st, 2020.
Okay. And that was also obviously given an MSO case number. What was that allegation?
Welcome, Wendy.
That was a physical abuse report.
Okay. And that was, again, by Ashley Benefield saying Doug Benefield was abusing the child Emerson.
Yes, ma'am.
I agree, Sarah. I'm
To
jealous.
your knowledge, did a deputy and a child protection investigator respond initially before you got it?
Yes, ma'am.
Okay. Before you could fully investigate that case, did another complaint come in?
A few days after that, on the 23rd, another deputy responded to Ms. Benfield's residence and conducted another interview.
Okay. So another allegation, same parties.
Yes.
All right. And what type of an allegation was that?
Also physical abuse.
Physical abuse. And did you investigate both of these reports kind of together?
Yes.
Did you ultimately close that case?
Yes, ma'am.
With no charges?
No charges.
And then the fourth report, can you tell me what date that was?
Report date on that was April 5th, 2020.
Okay. And what was the allegation?
Also physical abuse.
Same parties?
Yes, ma'am.
Same allegations. Okay. And again, a deputy and a child protection investigator responded. And at some point you were assigned the case?
Yes, ma'am.
Okay. And again, before you could fully investigate this, did another complaint come in?
That I don't recall.
Okay. I have something dated April 27th of 20. Do you have any notation of that in your file? With Deputy Schrank?
This is when he responded to Ashley's residence, yeah.
Okay. And so that was on April 27th?
Yeah.
And that was another allegation, correct? New bruises and sexual abuse?
Allegation of bruising marks, yes.
Okay. Same parties?
Yes, ma'am.
Did you investigate this case or these two cases?
I did.
And ultimately you closed those with no charges?
That's correct.
Thank you. I have no further questions.
Good. That was quite simple. I think she could have simplified it even more, but
Cross.
No questions for Detective Boyle.
All right. Can the witness be released?
Yes.
Yes.
All right, sir. You're released from your subpoena. Thank
Thanks,
you.
sir.
happy days. Next witness, please.
Okay. Don't bring in Dr. Broder yet. Thank you, Deputy. All right. Go ahead and put your objections on the record, and then I'll hear from the state.
Your Honor, for this, I rely exclusively on the Florida Evidence Code, which is really, really clear about character evidence. And
Oh, Wendy.
what Dr. Broder is going to testify to about Ms. Benefield and his conclusions clearly.
Thank you
go
so much,
to
Wendy.
character. And the evidence code says in no uncertain terms, it's inadmissible until such time as the defense puts.
Very
her
kind of
character,
you.
If at all, in issue. What is admissible is Douglas Benefield's character. According to that same statute, I gave the court a memorandum on it.
I see Swift.
While I haven't spent that much time before the court. I have spent enough
Yes, you
time to know
too.
that the court reads everything. So I know Your Honor has reviewed it. I don't think, honestly, Judge, there is an exception to it. And what I'm particularly concerned about is.
Yeah, thanks,
the
Ray. I do
state is about
appreciate it.
to call a
Thank you.
professional who's going to opine as to characteristics of Miss Benefield that really have no place in this hearing. And while I firmly believe at the end of the day, the judge, Your Honor, will parse this appropriately, I have some real concerns about this kind of testimony and whether or not the court would be capable of that. So I think it's improper.
All right. State, what do you expect Dr. Broder is going to testify about?
Okay, there are several things. Most of what I try to keep Dr. Broder's testimony to is his observations of the defendant and the victim and the child. Also things that the defendant told him. So I try to section this out to sections that I did not believe would be objectionable. But then there is a section where he does talk about some testing that he did, and some of his opinions and diagnoses of her would suggest that she has, it would probably be improper for me to get too far into it, but suggests that she does exaggerate facts, that she does exhibit paranoia about things. And I think that is highly relevant to the self-defense argument. First of all, I believe the defendant has put her character into question by asserting self-defense in the motion, even though we're not technically in trial. But I do agree that character evidence only has certain ways that it can be proven, and that's not what the state's trying to do. What the state is trying to do is the court has to determine if this use of self-defense was valid based on the facts as they were known to the defendant at the time. And as I've argued before, the only person that knows the facts as were known to the defendant at the time is the defendant. And if a professional has investigated her and evaluated her extensively and says she has a tendency to exploit the facts and exaggerate the facts and be a victim when she's not necessarily a victim, I think it goes to the facts as seen by the defendant at the time and the reasonableness of her belief that she used it.
All right, so let's talk about that one first. And you can sit, you don't have to.
Okay, it's just hard.
I understand.
Remember to do that.
And if you want to, that's fine. If you want to stand up and move around, that's fine too.
Okay.
So we certainly have to look at the use of force as informed by the facts and understanding that the defendant had on that day, which sometimes misleads folks into thinking it's a subjective test. It is not. It is knowing the facts that would have been within the defendant's ambit of knowledge at that time. What would a reasonable person have done? So I don't look at what would a reasonable person who tends to exaggerate situations. I'm not concerned with a reasonable person who's paranoid or mentally ill or schizophrenic or any of those. I'm just, what are the facts that were available to and known to the defendant? And were the actions of the defendant reasonable in looking at it from the perspective of a reasonable person? So I guess I'll say that I'm not seeing, and I'll come to you. Don't think I'm not coming over there. I am. But before I go over there, I want to make sure I understand what the testing of the defendant and the diagnosis that she exaggerates and may suffer from paranoia, to the extent that those are diagnoses, DSM-4 or 5, whatever we're on now. So I want to hear a little bit more about that, but also what the observations of the defendant, the victim, and the child, what those are, when were they, and what's the relevance of any observations that that witness may have made. Defendant statement's another issue. I'm not going to spend a lot of time there because if she made statements to him, as long as they're relevant, they're coming in. But those two things, I'm not quite understanding the testing of the defendant and any diagnoses by Dr. Broder and how that's relevant to the
Who's Gabriel Fernandez then? I don't know who that is. Should I know who that is, Spidey?
objective person standard, and then the observations of the interactions between the three of them.
Okay, which one do you want me to take?
Whichever one you want first.
Okay, Judge, as far as the testing, I agree that it's an objective standard. But if your only recitation of the facts is told by someone who suffers from histrionic personality disorder and makes herself a victim all the time, then her view of the facts, it goes to her credibility, her view of the facts as is being put forth in the motion and possibly in this courtroom is not necessarily as reliable.
Let me ask you this. Is the defendant's motion substantive evidence that I can consider?
I think the defense would say it is.
But I'm asking you.
No.
I don't know. I've
Understand
not heard of that.
Is the defendant's motion substantive evidence that I can consider?
Absolutely.
And you have a case that says that. I don't think it's not sworn to, is it?
No.
Now, hold on. Let me say this. I completely understand that in order to make a prima facie case, and I believe this as well, not just, I know this is the case law, that a motion to dismiss under the standard ground statutes does not need to be sworn to. All it has to do is set forth a prima facie case. So with that said, though, how do I consider that as substantive evidence when it's a motion written by the attorney on behalf of the client? And I don't see any manifestation of an adoption of that.
Well, I can answer that. number one, the state has stipulated and acknowledged that it meets the prima facie.
That's it.
threshold.
That is a pleading threshold.
Yes.
That's not a substantive evidence threshold. All it is a pleading threshold.
All right, and the appellate court has said that Your Honor is obligated to take the averments as true.
In determining prima facie, and I agree, there's a prima facie case. My question is, under what authority, so I'm looking for a statute, a rule, or a case, says that an unsworn motion to dismiss under stand your ground can be considered as substantive evidence?
Well, I think at this juncture, the only inquiry for the court is whether or not the state produces evidence clearly and convincingly that the force used was not justified.
100%, I agree with that.
And that therein exposes, I think, her argument in this sense. Whether or not Miss Benefield exaggerated.
Just in case people can't make it.
Nothing to do with what the state, at least up until now, has yet to produce. I was going to use scintilla of evidence, but I'm kind of burned on that one. Has yet to produce any evidence whatsoever, which is the violent nature of Douglas Benefield. And was my client, the objective standard, on that day, knowing what she knew about him, firing the gun in the kitchen, placing a tracker on her car, was she justified in resorting to deadly force? I've yet to hear anything about that refutes that. I only have heard a case that is intending to show motive.
I appreciate that for your closing argument. My question is much, much more narrowly tailored. Can the court consider the defendant's motion to dismiss for stand your ground reasons? It was written by the attorney, is not verified, has not been adopted as a defendant's statement, as substantive evidence. And so we'll leave that right now on the table because I'm not aware of any case law that says it's substantive evidence. But let me come back to you. And I think I kind of got off on that tangent. Based upon the observations, is that where we left off? Or is this still on the testing?
Well, enjoy the vacation, Wendy, at least.
Okay.
So, yes, I think that's where we were. We were talking about how the court does have to determine the facts as known to the defendant, and we are evaluating.
Right, whilst they're talking, right, I'm just to clarify, because we're doing Johnny Depp tomorrow, I know some people will be going to watch it live tomorrow with Solomon, but those that can't see it, or if it's just on Rumble, I'll be replaying it on the stream at 4 p.m. Eastern for those that can't watch it live. But if you can't watch it live, please go and do so. The link will be on Viva Free. But I can't because I'm doing Johnny Depp. But I will still be in chat during it, but I'll be streaming Johnny Depp and have that on the side. So I'll be in chat. But I want to watch it. So I'll have it on mute. I want to watch it. So that's why I'm streaming again at 4 o'clock then Eastern, just to clarify. Idaho, USA, happy days in the mountains. Oh, you got some internet, Jesus.
What's known to the defendant, I think the credibility of how she views things is highly relevant to the recitation of facts. And so I don't know how the substantive evidence or non-substantive evidence in the motion to dismiss plays into that. The burden has shifted to me. She has said self-defense, so I do feel like we have to prove otherwise. So the fact that she has these traits and has been seen to do it, I think plays into the facts as known to her.
I think if there's going to be substantive evidence in front of me, all I know right now is that a prima facie case has been played. That's it. Now the burden shifts to the state to prove by competent and substantial evidence that proves clearly and convincingly.
The message you sent didn't say.
But I don't think the facts as alleged in the defendant's motion are substantive evidence.
Oops.
I don't.
There you go, Spidey.
My notes, but I know there's been a lot of cross-examination on allegations of prior violence and so forth. And my take on that all has been, well, yeah, I heard about that, but not yes, that happened, or yes, it's true. I haven't received. I just don't consider that as let's just call it proof.
1 o'clock live on Viva's channel, and 4 o'clock here, just a replay.
Whether it's here in court or was it a recorded statement? Okay.
So it'll be after the Johnny Depp.
I just don't think that beyond the fact that there's
the Johnny Depp one, 3 o'clock. Sorry, 10 o'clock Eastern.
Rebuttal where Dr. Broder can bring that all in, but at this point,
10 o'clock
I don't
Eastern.
think it's relevant to preemptively show that she exaggerates or is paranoid. All right, now on the observations.
On the observations, it again goes to the state's allegation of motive that she is trying everything to get rid of this victim, and she's tried violence against her and it hasn't worked. She's tried violence against the child and it hasn't worked, and so it goes to her credibility and motive that she's telling the victim one thing, she is acting another way in private. It shows that she is being manipulative and she is not at all wanting to have this nice family relationship, which goes to her motive to get rid of him. She doesn't want him around.
All right, let me take even a further step back. And this is an example of where you guys know the case so much better than me. What observations do you expect Dr. Broder to testify to? I saw it on this day. I saw this on.
The seeing is mostly with the child because the allegations were of abuse and the seeing is the child interacting with mom and dad. The rest of it is the defendant's statements.
All right, so the observations, I'm only talking about that right now. The observations portion, which was number one of the testimony you intend to elicit from Dr. Broder, is that he observed the decedent interacting with the child, Emerson, presumably in a positive way. And the child didn't exhibit any external manifestations of fear or.
Correct.
Okay. When were these observations made?
And I have to look at my questions, but the report was set to come out. It came out, I think, a week before he was killed. So he met with them 10, 15 times. So I'm not sure exactly what date, but I can tell you when he was asked to do the report, when he was assigned to do the evaluations of the two of them. It was. They don't have a date. Hang on, Judge, I'll find it.
Let's skip this bit. Come on. Should be better organized.
Simply to show that she didn't seem afraid or scared of him. So that should be one question.
I think he's entitled to say why.
Well, I mean, yes. What did you observe? Because otherwise it's conclusory.
Right.
But he's got to put the facts on there. But
Right.
okay. And I'm going to come to you in a second to hear your other portions. And then on the defendant's statements, I mean, how numerous are these? If they met 12 times, are we going to hear hours worth of defendant statements?
No, I don't know how long it's going to be, but there's several statements.
Okay. I don't know what they are. All right, sir, Mr. Taylor. So I've already said I'm not going to allow the testing and the diagnosis until I think there is substantive evidence in the record of defendant statements or character that would allow that to be used. Maybe in rebuttal, we'll see. But now to observations. Did you want to be heard on the observations of Dr. Broder?
Well, let's assume, I think the court got to it right quick. Let's assume that he's going to come in and he's going to testify. I observed Douglas Benfield with Emerson, and Emerson appears to be quite happy. Okay, so that's, I guess, another way of establishing that the complaints were closed with no finding. So it's, I guess, reinforcing the state's establishment of motive. So the question becomes, for something that's not an essential ingredient of this hero, that does not go to one of the facts in issue, just how much reinforcement to the non-essential element is the court going to allow? I don't think that there's a thing that Dr. Broder is going to say about observing the interaction between the father and his daughter that's adverse. I think the court figured that out pretty quickly. So then the question is, so what's the relevance of it? What's the benefit of it? What's material to it? Because it does not run to supporting any fact in issue. What I do think, Your Honor, is that if she is allowed to call Dr. Broder and Dr. Broder is allowed to testify, I believe I can question Dr. Broder about his conclusions as they related to Douglas Benfield. I think that the evidence code clearly provides for that. I have alleged that Douglas Benfield was violent. I've attached to our motion, which I think the court can consider substantive evidence, admissions by Mr. Benefield under oath. And I am entitled to bring out from this psychologist, who the state is going to call, that he concluded Douglas Benefield suffered from obsessive compulsive personality, and that somebody with that
Oh shit! What do I do there?
suffered from obsessive compulsive personality, and that somebody with that diagnosis likes to control their circumstances, their situation, which would include, according to Dr. Broder, quote, their marriage, parenthetical, Ashley, and parenthetical, quote. Dr. Broder also
Good point, Spider.
Ashley's chief complaint, which is that he's violent, he's jealous, he's manipulative. These are things that she feels. If the state wants to
I know,
cover it,
I know,
think
Wendy.
it's very fine.
Jesus.
All right, I I don't know, because I haven't heard his testimony yet. It may be within the scope of direct, and it may be outside the scope of direct. I don't know how far they would get into that. I think that's more of a game time decision. All right, State, any final thoughts?
No, I just want to put on the record that I disagree that if I do get into certain things about the defendant, that it opens the door naturally to talk about his impressions and diagnosis of, I think I would like to see that ruled out.
And that's why I said I don't know. Because I don't know what his testimony is going to be. Certainly, it's something that could happen. I don't
Have a
know.
good time, Wendy.
Maybe
Enjoy
it's
yourself.
relevant
Thanks for
to some
popping
issues
in, and
raised,
thanks
I
for
don't know.
the
But more specific to the observations
super
that
sticker.
Dr.
Really
Broder made
appreciate that.
regarding
Thank
the
you.
interactions between the decedent
Enjoy the
and
rest of your
the
vacation.
child. The ruling is much like I just made with Detective Moreland. If you want to get a little bit at, because, and let me be clear,
See you soon, Wendy.
if I'm understanding how this is going to come full circle, that a couple of days before, this is what I'm understanding from you and from what I'm piecing together as we go forward. A couple of days before the incident alleged in the information, Dr. Broder issued a report, and that the defendant would have seen that report, seen that Dr. Broder made positive observations regarding the interactions between the victim and the child, and that supports the state's theory of why she did what she did.
Your Honor, I'm sorry to interrupt, but Ms. Benfield never saw the.
And that's what I'm trying to understand.
Right, that they did a joint motion to disclose but they had not seen it. I would agree with that.
Right. So what again would so then here's where I'm left. Dr. Broder comes in and he says, around the same time that in the spring of 2020, that
And I'm sorry, Judge, I did not find the date. It's June 1st, 2020.
June 1st of 2020 is the order appointing him.
No, that's when he started his evaluation.
All right. That's what I thought it was for. So then I need to understand again, what is the purpose? What's the relevancy of Dr. Broder's observations of seeing the child have positive interactions with the father? And again, my assumption, I'm sorry, I assumed, was that somewhere along the lines, the parties saw the report or knew about the report. And then your theory was then the defendant said, oh, now even Dr. Broder's not supporting me. Now I have to do something else.
And I ultimately do believe, and that's what I would be arguing in a trial, and that is actually what was happening. I think it's the state's argument that the defendant knew that this positive information was going to probably come out in this report.
How do you know she knew that?
I know from some of the interactions that were going on between her and Dr. Broder, and some of the interactions that were going on in a group, the three people with Dr. Broder. I can impute it to her that she could see what was going on, and she could see, how Dr. Broder was leaning.
I think she's grasping
She
straws
knew that
now.
That report was going to come out and be given to Judge Moore.
So now if I'm understanding, it's going to be Dr. Broder's observations of the interactions of the decedent with the child in the presence of the defendant and how those were positive.
I don't know. There were some that were not in her presence and some that were.
Clutching at straws.
To the extent, I don't see any way to make it relevant to any issue that I need to determine, but for what effect it might have on the defendant. So to the extent there were some observations of positive
speculation.
interactions between the decedent and his daughter when the defendant was present in the presence of Dr. Broder, I'll allow that. But then that's about it.
Sorry, if you could repeat that.
Positive interactions between the decedent and his daughter in the presence of the defendant and in the presence of Dr. Broder. And then I can see how that fits in, and that is relevant to your position. Otherwise, I just don't see the relevance of it.
And my only other argument, Judge, and you may still have the same opinion, but it also goes to the defendant's credibility, saying this child was abused, this child abused, this child abused, this child abused, and the child was acting like this, then her credibility is exactly what's at issue in this case. So.
And that's why I asked about the date. That's why I wanted to know when was he making these observations to see if it coincided with the reports that were being made, and it doesn't. It's several months after.
It was 6 weeks to 2 months after.
It was. So, no, that'll be what I'll allow.
Okay, so let me make sure I have it straight because it's late. So we're not going to talk about the interactions not in the defendant's presence.
Correct.
And we're not going to talk about diagnosis.
Correct. Unless those later on become relevant.
In like a rebuttal or something.
Sure.
Does the court have any thoughts on cross-examination about my continuing to attack the nature of Douglas Benefield?
I'm just going to leave that open to whether it's within the scope of direct or not. It may not, and it may be. I don't know. But if it's not, then yeah, I would sustain because it's beyond the scope of direct, and then you could call him, and then it may be relevant and may be admissible. I didn't mean relevant. Admissible is the word I want. All right.
And Judge, if I could just have a moment to let him know.
Absolutely.
Okay.
Jesus. Well, what? I don't see the point of this witness. Five seconds. He's brought a suit. He could be there for like 2
Good afternoon. Please
minutes.
state your name.
Done.
Good afternoon, Dr. Brad S. Broder,
How do you spell it?
Broeder.
And it's Brad S., you said?
Yeah, S for Stephen.
What is your profession?
I'm a psychologist, clinical psychologist is my degree.
How long have you been doing that?
I received my degree from New York back in February of 1987, and then relocated here to Florida. Started my practice in January of 98 after I was licensed here in Florida. So this is year number 36.
Okay. And what do you currently do? Do you have your own business? Do you have a practice together with someone?
I'm a solo practitioner. I have run my own business, but I do serve as a consultant to Sarasota County and Manatee County Child Protection Team.
Okay. So what is your education to be a psychologist?
Well, I first earned my master's degree in counseling psychology and then went on to pursue my doctorate in clinical psychology.
And you have a sole practice, you said?
That's
Sole
correct,
practitioner?
yes.
And you do consulting work for the county? And who is that?
Yeah.
I'm skipping that.
I think that was the last thing I wrote down.
Florida is supposed to have a consulting work to advise, and then if need be,
You said
I mean-
that,
there will contact me and let me know that what's my availability to attend to staffing. And once or twice a year, I'm kind of on call, let's say, to conduct seminars or workshops.
okay. And what is a staffing?
The staffing is referred to as multidisciplinary staffing. PT,
I mean,
people are
yeah,
scheme.
he's
Myself,
qualified.
Or let me become involved in that.
I was contacted by Ms. Kimberly Griffin from the Manatee County Child Protection Team. She was at that point the team coordinator, and they had concerns based upon
Also staying as to the substance of issues
Okay.
that may have been communicated.
Based on, let me back up. So Kim Griffin is with, which agency did you say, CPT?
Manatee County.
Manatee County. And had she, to your knowledge, been involved in several prior complaints against Doug Benefield, lodged by Ashley Benefield?
There had been 3 complaints in total starting in December of 2019.
Okay. And you were asked to evaluate her, Ashley Benefield, correct?
That's correct.
And were you also asked to evaluate Doug Benefield?
Yes.
And what was your purpose of, what is your goal here? You're not law enforcement, so what is your goal when you do an evaluation?
Well, sometimes the evaluation might be just parent effectiveness. Sometimes you're assessing for substance abuse, but more often than not, it's an evaluation, psychological evaluation for mental health issues.
Okay. And did you in fact complete evaluations of both parties?
I did, yes.
Okay. Were these extensive evaluations?
As a solo practitioner, I pride myself on being thorough, so I would say yes, they're absolutely extensive.
Okay. So I want to talk about Ashley Benefield for a moment specifically. In preparation for your evaluation, did you review documents?
Part of any thorough evaluation would be looking at not just collateral context, interviewing other people, but collateral data, which would be whatever records are presented pertaining to the case and the family situation.
Okay.
In
and then
addition,
go ahead.
I'm sorry. In addition to the fact that I typically will ask the parties, the parents in this case, if they had anything else they wanted to share with me by way of, diaries, journals, photos, videos, whatever they might have. So the more data I have, the more inclusive it can be.
And you said collateral contacts. Do you make those contacts?
Yes.
Seems like we're going awfully far afield from what the court ruled.
I'm going to overrule. I mean, I don't think we've gone into things I've ruled not to go into, but
Okay. As part of your work specifically with Ashley Benefield, did you meet with her?
Yes, I did.
And did you meet with her alone or together?
In conducting these kind of evaluations, is a series of individual interviews.
is there an objection?
She interrupted the witness who was attempting to answer the question.
Okay, overrule. Go ahead and ask your question.
Did you meet with Ashley by yourself?
Yes, I did.
Okay. Did you also meet with her with other people?
I did a home site visit. So yes, I saw her and her daughter and her mother, as well as I'd seen her and her mother in my office, and I've seen her with just Emerson. And on a separate occasion, I'd seen her and Doug together, both in terms of conducting the exchange of their daughter at my office, as well as a joint meeting.
Okay. And when you say joint meeting, is that one where they sat with you and did therapy together?
Not therapy, it's an interview for the evaluation.
Interview for the evaluation. Okay. So how many times did you meet with them together? Do you recall?
I believe at least twice where we had a formal meeting, different than when they would exchange Emerson. And the
Okay.
point of the exchange in my office, just to share, is that it's important in the evaluation to oversee and evaluate it, to observe how the child responds, leaving one parent going to the other parent, how the parent handles the child in the separation, particularly because at that time, Emerson was just under 2.5 years old.
Okay. So she was pretty young, a toddler.
2 years, 4 months.
Okay. During your contacts with Ashley, How did she present when you first met her?
Objection. Beyond the scope of the court's ruling. The court's ruling was that Dr. Berger would be entitled to testify to his observations upon all parties being present. Ashley Benfield, Douglas Benefield, and Emerson.
And I'm sorry, go ahead. You look like
Go
you want to
ahead.
speak. Judge, I don't know that this has anything to do with the court's ruling. This is his evaluations of Ashley specifically. Her mannerisms, her speech, what she says is all relevant.
How?
Because it goes to the allegations that were made about the child abuse, then the fact that now someone is evaluating her. Now the fact that she is attempting to manipulate the evaluator goes towards the motive of the entire case.
Sustained.
What did Ashley tell you about her relationship with Doug?
Objection. Once again, beyond the scope of the court's ruling.
No, I said defendant statements we didn't get into. We didn't talk about the limits. Defendant statements weren't limited in any way. But with that said, so it's not a violation of the ruling I just made a few minutes ago, but maybe there's other objections that may be relevant or appropriate as we go through. But no, I mean, defendant statements they're allowed to come in under the rules. It's just a matter of whether they're relevant to any particular issues.
Did you speak with Ashley about her plans for the future with or without Doug Benefield?
Yes, that certainly came up in the scope of the overall evaluation.
And what did she say about that?
She made it very clear on more than one occasion that she had no intention of reconciling with Doug and that she had every intention of relocating to Maryland with her mother in Emerson, particularly because her grandmother had passed away and her mother had inherited that home so she could return to her native home state of Maryland.
And did she indicate to you that she was going to go without Doug? Go to Maryland without Doug?
Again, in several different occasions, she had indicated that was her intention. She did not want him to come along with her. There was some email exchanges indicating that she was trying to make that happen. He had made it clear that he was going to be going there and thought that he'd be moving in with them, which she clearly made clear to me that that was not going to happen.
Okay. So she made clear to you that he is not moving in. We are not getting back together.
Yeah, absolutely.
Did she say those things and act that way during the joint session with Doug?
No.
Okay. How was it different?
It was different in that her presentation of herself was more deferential to Doug because her goal, as she had shared with me, was to, in essence, kind of appease him, go along with him, because she was concerned he might get angry and blow up. So she wanted to just kind of go with the flow, as the expression is, and therefore she was willing to go out to lunch or go to a movie or hang out with him and Emerson. So she was not going to present that ultimate goal, certainly not with me. In those sessions, it didn't come up.
Okay.
I know.
Did you talk to her about the suspected poisoning in the past?
It's like tennis.
Or did she mention it to you?
That was an issue that came up, yes.
Okay. And did she believe she had been poisoned?
She was suspicious. She admitted that she didn't know for
She's calling for an opinion as to the substance of the comments. Did she believe?
Yeah, I mean, to the extent it asked for an opinion, we're talking about statements. What did she say?
Okay.
What were your observations?
What did she say to you about the poisoning and whether she believed or not that she was poisoned?
She had a very definite concern, a fear that he might have attempted to poison her. She was concerned first with during her pregnancy and felt ill, and then when she delivered the baby, she even didn't even want to attempt breastfeeding for fear that she had been poisoned. So she had refrained from that and went so far as to ascertain a toxicology report to that effect.
Okay. And did she ultimately admit and say, well, okay, maybe he didn't poison me?
I don't know. She certainly didn't say it that way. No.
How would she have said it?
He said, she explained to me a bunch of physical symptoms she had, and she was worried for Emerson, and she did admit that she did not know if he had poisoned his former wife, Renee, but she had that suspicion, but she could not say conclusively that he had attempted to poison her, no.
Okay. And did she indicate to you that something about, I know you're the professional here, but do you know what I'm talking about?
Yeah, I believe you're referencing towards the end of the evaluative period. She wanted a resolution, and she was very frustrated with the system, CPT, the courts, Judge Moreland, et cetera, because she felt no one was helping Emerson, no one was doing anything. I put in my report that she declared, I'm the expert, I'm not doing anything, and what's going to happen? She'll have to take matters into her own hands.
Okay. So she indicated to you that she specifically had a problem with the authorities, MSO, CPT, CPI.
That is correct.
Okay.
Imagine if she had man flu. She would be able to
And
cope.
at some point, did she say to you she needed all this to be done?
That's
We're running out of
horrible,
time?
man flu is.
Yeah, she did.
Tell me about that. What did she say?
It was during that same interview session where she really wanted to just kind of be able to move on with her life. She was looking forward. She explained to me that her mother had retained the hope of a realtor to sell her home in the Lakewood Ranch area, that they were preparing to move. That was her intention. So she just was hoping to relocate, reestablish herself. She shared with me that if she had been able to establish a permanent residence of at least 6 months, that she could then appeal to the authorities, the Child Protective Service authorities in the state of Maryland, in hopes that they would help her.
Okay.
I heard
And was she
Baker. I did
frustrated
call.
at
I did
you,
pop in and give you a like.
Because you weren't helping her?
Thanks, man.
To the extent it calls for speculation, if
That
she made
sucks for it going
words,
down.
then that's one thing, but
Did she ever express frustration or anything that would have led you to believe she was frustrated with you?
Objection to what she said. Did she say that?
yeah, that's how I take it. I mean, hopefully I'm being very clear. We're talking about not speculation or what you think or what you guess or what might have been. We're talking about words that were uttered by that person over there.
Ashley expressed her frustration at the overall situation. To the extent that I was part of that situation, then yes, but she never specifically singled me out.
Okay. And did she indicate to you that Doug was still abusing Emerson? Or that she thought Doug was still abusing Emerson?
Not at that point, because they, at her initiative, had agreed to basically spend time with Emerson together as a family. And so there were no, during the course of my evaluative process, there were no complaints or fears about that, which she attributed to her presence.
Did she discuss with you the past allegations of abuse against Doug?
She explained each one of them, yes.
Okay. And, but she said after that they were living as a family.
Not living, they did not live or stay together. They didn't even have any intimate relations. They would do things like take Emerson to the beach or go to his condominium unit to the pool, or they would go out as a couple for dinner and grandma would watch the baby and things like that.
But Ashley told you she had no intention of being with him.
Unequivocally.
During the time that you spoke with Ashley, did she ever say that Doug physically harmed her?
Not physically, no.
Okay. Did she ever say that she was afraid of Doug being violent with her?
She explained the gun incident in their kitchen in their South Carolina home, and that was certainly a frightening experience for her.
Okay. But did she say that would have been 4 maybe years before, correct? Before you were meeting with her?
I'll sustain.
Was that incident?
He's
did it just
confused.
happen, or was it a
What the
long
fuck's
time
going on?
It was well before my involvement.
Okay. Did she complain of any other things, acts of violence or aggression from Doug since then?
What she explained to me about Doug was that she felt that he had a violent temper. They would get into these yelling, screaming matches, and he would punch holes in the wall. Again, that was again in their home in South Carolina. None of that.
I
was
saw
really
Jamie
violent.
started in Discord
So
then.
during the time that you talked with
Sucks,
her,
man.
she never brought up anything more recent than South Carolina.
That sucks.
If she didn't say it, it's not included in what she did say to him.
Overruled. Go ahead.
Did she give you any examples of Doug's violence, any more recent than South Carolina?
Yeah, that's the one, Baker. It is, yeah.
Did she indicate to you that she was afraid of him while she was talking to you?
It's from Friday, so repeat.
You mean in the individual sessions? Or
Yes,
just she and
yes.
I? She did not present as fearful or worried about that. No.
Okay. When was the last time that you saw them? You recall?
Approximately late August. This is 2020.
And when did you do your report?
I believe it was submitted on or about mid-September. I think the 14th of 2020.
Okay. So when a report is submitted, it gets submitted to CPT?
The work product is the property of the child protection
Interesting,
team.
toxic.
So
Interesting.
that who handles it and anyone else who wants to see it would have to get a court order from the judge.
Okay. So even the people that you're interviewing have to get a court order to get that evaluation?
That is correct.
Did your sessions with Ashley and Doug together, did you have any concerns for the safety of Ashley or the baby after your sessions?
I did not.
No further questions?
Cross?
What's he got a cross on? Don't open the door now, you idiot.
Taylor, I have a few questions I'd like to ask you.
Certainly. Good evening to you too.
Only because it's the most recent, so we'll all remember it. And I recognize we're asking you questions that you're trying to answer from memory, which is not the easiest thing given the time that has transpired. But do you recall testifying at a dependency hearing?
Sustained.
Okay. Are you certain about your statement that Ms. Benefield did not express fear of Douglas Benefield to you in the past and continuing in the summer of 2020?
My notes in my report reflect that she had certainly expressed fear that Doug could not parent Emerson, and she was not comfortable with him having Emerson, like for an overnight, for example. So she wanted to do whatever she could to block that.
All right, may I approach the witness, Your Honor?
Okay.
Let me pass this to you and see if this helps you.
Yeah, take it in your own hands. That's not great, is it? But yeah, I don't know what to say about it, to be quite honest. It doesn't, well,
Does that
I
help
don't know.
refresh your recollection as to whether or not Ms. Benefield during the summer of 2020 expressed to you that she was afraid of Douglas Benefield?
Yes, based upon the previous experiences in South Carolina.
Depends who you talk to, I think.
All right, now, the judge has restricted us, as Ms. O'Donnell told you, to things that Ms. Benefield told you. And you've been very candid and helpful, but I want to just ask you a few additional questions. She told you, among other things, did she not, that Doug had he was very angry with a real temper?
She expressed that he would get very angry, yes.
She expressed to you, told you that he was very controlling.
She certainly felt he was controlling, yes.
Yeah. In fact, I believe she said to you that he was highly manipulative.
I don't know if she used those exact words, but she felt that he was controlling, yes.
Let me see if I can refresh your recollection.
Yeah, but you don't have to. You don't have to. He just said highly controlling. Happy days.
May I approach him, Your Honor?
Yes.
Let's see if that refreshes your recollection.
The judge
as to whether
gets
or not
it.
Ms. Benefield told you that Doug Benefield was highly manipulative in those exact words.
He gets it. I mean, maybe he doesn't get it, but
That's my statement, yes.
cool. Move on, all right?
She told you that he was very intense,
Yes,
that he punched holes in the wall,
that's true.
fired a gun in the ceiling of the kitchen, and she discussed with you her fear that he poisoned his first wife and perhaps her as well.
She admitted that she didn't have any proof of that, but she was suspicious that he had poisoned Renee and that she therefore had similar suspicions that he might attempt to get rid of her.
All right, and lastly, I want to ask you, you mentioned, and I think the word that you used was appeasement. This was the strategy that Ms. Benefield told you she employed for going along with Douglas Benefield in an effort to protect her child, Emerson, correct?
She felt the best way to protect Emerson was to appease him, yes.
Yes. I believe the way you characterized it was to keep him, Douglas, at bay.
Yes.
Okay, sit down.
Nothing further.
All right,
Thank you, Doctor.
redirect.
So defense just asked you about Ashley saying she would go along with Doug to protect Emerson, to keep Doug at bay, correct? Did you have any concerns about Doug being with Emerson?
Objection.
The door has been opened, Judge.
You know what? I'm going to allow it. I think the question was asked. Go ahead.
Did you have any concerns about
What did I say?
Doug being with Emerson alone?
Well, let's
What
put that
did
in
I
context.
say?
When you're doing these kind of evaluations, you have all sorts of hypotheses to start out with. But as part of the evaluation, I have to see parent and child together, both in terms of the separation from one parent to the other, as well as their interaction. After observing him with Emerson, and the first time just happened to be due to scheduling issues at his own apartment, I did not have any concerns at all.
Okay. And did you observe the two of them together?
Yes.
The child and the father?
Yes.
Okay. And was there anything about their interaction?
Let's just make a seat a bit, man.
Emerson had been with her dad in the pool that afternoon prior to my arrival, and when I got there, she had just woken up from a nap. I was a complete stranger to her, and she therefore clung to her father and stayed on his lap and cradled herself, and he was comforting her and soothing her. And I kept my distance to see, and I talked, and it was pretty clear that even as she's waking up, she was looking to him for comfort.
Okay. And so Ashley says she's staying with Doug just to protect her daughter. But this is a situation where CPT and law enforcement had all been involved, and it culminates in you. And did you have any concern about Doug being with his daughter?
I'll sustain. That's been asked and answered.
So Ashley said to you that Doug could be violent or angry, punch a hole in a wall, things that happen in South Carolina, correct?
Yes.
Did she ever say anything to you like, I am so scared he comes after me all the time?
No, she never used that expression or that phrase.
Did she ever say, I was afraid anytime that he was going to hit me?
No, she never expressed that at all.
But yet she's scared because he's so violent. Correct. She said she's scared of him because he has a violent tendency.
Yes, but the context was typically about how can she best protect Emerson, and how come I and the rest of the quote unquote system were not doing enough to protect Emerson.
Okay. Thank you. No further questions.
All right. Can the witness be released?
Yes.
Yes, sir. All right. So you're releasing your subpoena. Thank you very much.
Thank you, Your Honor.
Before the defense attorney went up there, said, "Be careful, don't open the door." And what does he do? He opens the
Dare I
door.
ask? Oh, well then, you solved that issue. I was gonna be the bad guy and say, call the next one. But that was not a popular opinion, just so you know. All right, any idea, can you give me an idea for planning purposes for tomorrow?
Judge, I think it will be the defense case tomorrow.
Okay. I'm not, so don't rest yet, but
Right, that's the end of that one. Let me get the other one up now then. Right, hang on. Right, here we go. What's she saying? My issues with all this minimizing what he did by everyone. Controlling and manipulative are two very different things. Manipulation is definitely worse. Okay, that's fair. I'm minimizing it. However, the fact she shot him when his back turned was clearly not a threat. They manipulated each other, in my opinion. She did her fair share of it. I haven't got an opinion yet. I've not looked at this case enough. I know there's DV involved, but the shooting and stuff, I've not looked at it. Yeah, Spidey's on it. Here we go. I don't know. This is why I think this is a complex case. I don't think it's black and white. Right, we got this now then. Right, for whatever reason they've muted it.
No intention of reconciling with him.
It's on their side. I think that's the point. I think. Well, right. Hang on. Let's see Spider. Right. There's a defense. Like, so I disagree with Spider on this one. Right. I did disagree. I should say. I don't anymore because I don't understand guns. But there's a defense for that as well. People move. She fired 4 shots, 2 missed. He could have pivoted, in shock, and she was unlucky, and it hit him in the side back. So I obviously called BS on that on Friday, but since understanding how guns work a little bit more, I think that's very plausible. I haven't seen the whole thing, so no, same here. Toxic's seen a lot more than we have, obviously, so we'll have a different opinion, but that's not a bad thing. She uses to try to manipulate him. No respect for anyone who uses their child as a pawn. He was unarmed, wasn't he? No idea if he was unarmed or not, and I've no idea if she did use the child to manipulate him. I mean, there's signs of that, yes, but I'm not there yet with that one. I also thought you probably are more advanced than us on this case as well, so.
No intention of her secret was up at that point. As soon as Doug Benefield got that report, he was going to know that she had no intention of reconciling with him. She had no intention of even having to share custody of his child with him. So that date was sort of D-Day, if you will. And
so I believe what's going on here now is that both sides have rested. So now it's like closing arguments in a way of why the trial should or should not go ahead. Yeah, he's always got a loaded weapon on him, yes. And there's normally one in the chamber, he said, or something.
the defendant knew that. When this
Or is it the
shooting
chamber
took
or the
place,
whatever you call it?
the only evidence that you have of self-defense, other than my husband attacked me, is what's in the motion, which is not substantive evidence. There are pictures that there may be a scratch on the side. There may be a little scratch on the abdomen. And you can see from the pictures taken the day of, 3 days later, and also the booking photo, which is about 5-6 weeks later, that she has no swelling, no bruising. There is nothing wrong with her body except for those scratches on her abdomen.
There is nothing about those injuries to signify a need or it being reasonable or necessary to pull out a gun and shoot someone. And the physical evidence, while it does not give us definitive evidence of what exactly happened, it does give us some information. And I'll just remind the court, the shot was not straight on. The kill shot, the shot to the abdomen or the chest was not straight on. The shot came from the right side and ended up on the left side. Now, did it have a little bit of a front to back? Yes. But Dr. Vega testified it was basically from side to side. So any implication that this defendant was coming at her at the time of the shot is disproved by the fact that he's turned sideways, at least when that shot happened. Then you have the shot to the leg, which is it is the right leg from the back calf out the knee, or right below the knee, on the outer side of the leg, at an angle that he would either have to be falling backwards, and the way Dr. Vega explained it, he would have to fall backwards, and basically his feet would have to be at the level of his face for that shot, if someone were standing, for that shot to have gotten that trajectory, that path. He would have had to have fallen and his feet slipped up in the air. And that is just not reasonable that someone would fall that way. What is more reasonable is that he had turned and was beginning to run, and the calf was up this way when the shot was fired. So there is no evidence of what danger there was. There is no evidence that there was any necessity to use deadly force. We have no substantive evidence of any of that. All we have is that at one time she said that he was attacking her. Even if you take that as substantive evidence, what does attack mean? Does attack mean push? Does that warrant a shot? Does attack mean, elbow? Does that warrant a shot with a 45? No. The court has none of that information that would justify use of deadly force. So the court must rely on what the state has presented. And the state has presented a vast motive to get this man out of her life so she can have this child to herself. She's manipulative. She is telling him one thing, telling everyone else something else, and telling people that she's afraid of this man, but yet texting with him, inviting him to Selby Gardens. Why would she invite him somewhere? She's so afraid that he's going to do something. She's also on a video within days of the murder where she is trying to tell people that she's so afraid of him and what he would do to Emerson and these types of things. And she's on the video while they're playing a game in a restaurant, and she's laughing. And does she seem scared? No. Because I know the court can take into consideration the defendant's past experience with this victim and why she may be scared and why that fear may be justified. The only evidence you have before you is that there isn't any. And this defendant knew that she, 3 days after the shooting, had to be in front of the same judge that was not favorable to her. And this report was going to come out, and it was going to blow her story out of the water. And it was going to say that she was not planning to reconcile with Doug. And quite frankly, the fear of what the judge would do at that point was enough. So twofold is that she had a definite motive. Second is there is absolutely no evidence of reasonableness or justification or any reason that this shooting would have been truly self-defense. So on that grounds, I would ask you to deny the motion.
Mr. Taylor, before I get started, one thing I didn't do whenever you rested was just to clarify, Ms. Benefield, I do need to have a little bit of a conversation with you. So if you raise your right hand, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do so.
All right, ma'am, you can remain seated. Do you understand that in this hearing, you have the right to testify, you have the right not to testify, you do have the right to remain silent? Do you understand? You understand you've chosen not to testify? And is that your decision and your decision alone after speaking with your attorneys and consulting with them? And you also have the right to present evidence. You don't have to, but you could present documents, videos, the testimony of other witnesses. You have that right. You understand? You understand that you and your attorneys have decided not to put on any evidence?
Yes, sir.
All right, and you're okay with all of that? All right, thank you, ma'am. Just want to make sure. Thank you, sir.
That's weird that they didn't put anything on.
Your Honor, good morning. So I'd like to start, if I could, with the statute's elements, the stand your ground statute.
With a shot in testimony of the prosecutor. Yeah, I'm a little bit surprised. That's why I'm surprised they didn't put anything forward, because I don't think the prosecution have a solid case here at all. If anything, might be an unpopular thing. I'm surprised that she didn't testify. Only because, is it not better to do like a trial mock, for her to have a trial run with testifying? At least it's with a judge, not with a jury. Do you know what I mean? So I think it's, I don't know. I don't think it's that strong a case that they've got here. I don't know. It's, an interesting one. I'm surprised the defense didn't put anything forward though. Walking towards her, then she had reason to shoot. We need to know the trajectory. Yeah, we do. We do. I think maybe he was backing away. I had no idea. I don't know it, but it could be what Spidey was saying about like he was coming towards her, then she shot, and then she panicked and shot and missed, and he just ran away, and then she hit it. I don't no idea. But
Specifically,
you're right.
Your Honor, I'm referring to 776012, use of threat, use of force in defense of person, subsection 2. It's got basically three elements, Judge White. The individual claiming the stand your ground needs to be in a place where they have a right to be. This was Miss Benefield's home. The second element is that the individual claiming the stand your ground defense needs to have not been involved in criminal wrongdoing. Miss Benefield was not. And the third element, Your Honor, is that the individual seeking immunity under the statute needs to have felt that under the circumstances as they perceived them at that time, that the use of deadly force was justified for fear of great bodily harm or death. We have filed the stand your ground motion and made averments therein. Specifically, Your Honor, as to the facts that Miss Benefield knew about Douglas Benefield at the day and time of this shooting. They are, beginning on the first page of our motion, that he fired a handgun into the ceiling to intimidate her from speaking any further, that he threw a loaded gun at her, that he punched their dog in the face hard enough to render the dog unconscious, that he regularly carried a loaded concealed firearm, that he unlawfully placed a tracker on her car, and Miss Benefield frequently observed him tailing her car, that he was caught by a neighbor at night standing in her backyard and peering into Miss Benefield's home, that he punched numerous holes in the walls of their home, and that his previous marriage had a history of domestic violence. Now, again, this is what Miss Benefield knew and believed on that day. And this has never been addressed in this hearing. It's been ignored. Now, I understand why it's been ignored. Miss O'Donnell's competitive. She's a good lawyer. She's presented what she could. She doesn't have any evidence to rebut this. But, again, as far as Miss Benefield's belief and understanding on that day, we attached to our exhibits Mr. Benefield's own admissions about not only firing the gun in the house, but I think it's, again, because it runs to what Miss Benefield believed and knew at that time, this is the individual she was married to. In his deposition under oath, which we attached to exhibit number 1, Your Honor, which was taken on July 17, 2018. He said,
Did this come out in the hearing?
Well, I think that's one of the issues that we kind of discussed yesterday, whether the motion and its appendix or its appendices are substantive evidence.
again, this is what Miss Benefield knew, though. And the standard is what she knew on the day this happened. Okay, so whether it's substantive evidence, Your Honor, or procedural default, this goes to what Miss Benefield knew and believed on that day.
I understand. I think the defense position is that it's substantive evidence. The state's position it isn't. So, absolutely.
You were the one, question, you were the one reading from page 64. You were the one that threw the gun against the wall, correct? Absolutely. And I admitted to that. Question, you were the one that pulled the gun out of the sleeve and discharged it. Absolutely. And I admitted it. But you think that it was her fault? Answer, absolutely. And she should have stopped when you told her to, correct? Any one of the 100 times I asked her to. Again, on page 67, when you threw the gun, the effort was to make her shut up. No, that's not what was going on in my head. My head was pure expression of frustration. Question, do you see where it says right here in your own document that's now part of Exhibit 3, I threw it to make her shut up. Do you see you wrote that? Answer, yes. This is your writing. Answer, Question, yes. Answer, yes. Again, Your Honor, in the deposition of July 17th from page 72, Question, and you admit that that happened on or about that day you hit the wall to get her to stop talking. Answer, I hit it out of frustration. It had the effect of stopping her for a minute. Page 73, question, so you hit the wall where? I was inside the closet and hit it from on the inside of the closet, just about where there's an ADT alarm. Question, it put a hole in the wall? Answer, yes, it did. And then it went through. My fist went through the sheetrock and sort of hit the outside. Your Honor, I can't imagine. I know when I'm at the range, and most people, I don't know that I've ever seen anybody at the range without earplugs. I cannot imagine the terror of having a firearm shot while I'm sitting at the kitchen table in my house into the ceiling. I don't think the intimidation that would accompany that type of intentional act, and make no mistake, it was intentional because he admitted it was, I don't think that kind of intimidation easily disperses. I think it stays with someone for quite a while. One might even suggest that that's the kind of act that creates post-traumatic stress. It has never been addressed in this hearing by the state. It's been ignored. They haven't been able to address it. And again, the quote from Jefferson, Your Honor, is very, very telling. And I might remind the court, in the Jefferson case, that was on a writ of prohibition. The trial court had denied Mr. Jefferson's stand your ground motion, and the appellate court came in and stopped the trial and reversed it. And this is what they said. We are mindful that there will be situations where the accused is the only available witness to the events leading to an act that is claimed to be justifiable use of force. This may result in great difficulty for the state to overcome the accused's prima facie claim by clear and convincing evidence. But our result here is mandated by the text of 776-032, subsection 4. So what we also know from both the Jefferson case, Judge White, and the Riggins case, again, both second DCA cases who have spoken pretty definitively on stand your ground motions, is that the court must take the averments as true. And what I would suggest to Your Honor is that whether it is substantive evidence or procedural default, it brings us to the same conclusion. The state has not only failed miserably to meet their burden of clear and convincing evidence by disputing it, but they've never addressed it. They have not presented one word to show that Doug Benefield was not violent. The Casanova case had this to say about that, Your Honor.
1 second. Yes, sir, I got it. Thank you.
Based on the Second District Court of Appeals decision in Jefferson versus State, contrary to the lower tribunal's order, we conclude that a defendant's motion to dismiss under Florida stand your ground law can establish a prima facie claim of self-defense immunity from criminal prosecution, even though the motion to dismiss is not sworn to by someone with personal knowledge or supported by evidence or testimony establishing the facts in the motion to dismiss. That's a pretty powerful and definitive statement, Your Honor. Another thing that the state has left entirely unaddressed is the fact that in this motion, we alleged that this crescendo built over the course of time on that day with subsequent anxiety attendant to Ms. Benefield based upon the actions of Mr. Benefield. Specifically, we cited and averred that at one point in time, Ms. Benefield said, I've had enough. I want you out. You need to leave my house now. We've clearly established Mr. Benefield did not live there. We then further articulated that when he would not leave after she issued and finally found the strength to confront him and tell him, get out, she decided to leave. What did he do? He grabbed her by the left hand, turned her around, blocked the door, and would not let her leave, which resulted in her fleeing for sanctuary towards the bedroom. The reason why that's so significant, Your Honor, is because the Cummings decision dealt with exactly that situation. And they referred to that as a remaining in burglary. I don't have to quote the statute for the court. I'm sure the court is quite familiar with Florida's burglary statute. But I can tell the court this. The facts in Cummings were very interesting. As the court may recall, it was a couple. They were not married, but they cohabitated, lived in a trailer park. They went to a tavern to have some drinks and befriended another couple, also unmarried. The party continued back at the home of Mr. Cummings, where Mr. Cummings and the invitee got into a drunken brawl. The appellate court said that at the moment the invitee began to fight with Mr. Cummings, his license, his invitation, his right to be present in the home of Mr. Cummings by law was revoked, and his status was that of a burglar who, by virtue of committing a simple battery against Mr. Cummings, made him a forcible felon. And as the court knows, under 776.031, subsection 2, Your Honor, use or threatened use of force in defense of property, this is what the statute says. A person is justified in using or threatening to use deadly force only if he or she reasonably believes that such conduct is necessary to prevent the imminent commission of a forcible felony. Under Florida's burglary statute, which I've cited for the court in our stand your ground motion, burglary is a forcible felony. A person who uses or threatens to use deadly force in accordance with this section does not have a duty to retreat and has the right to stand her ground if the person using or threatening to use the deadly force is not engaged in criminal activity as in a place where she has a right to be. Once again, Mrs. Benefield's home, simply packing, not engaged in any activity in any stretch of the imagination that could be considered improper. And given what she knew on that day about Douglas Benefield, boy, did she have every reason to fear him, especially after he refused to let her leave her own home. According to Cummings, he lost the right to be present at that moment and was a trespassing burglar.
He's doing well though.
We don't want to discuss the remaining in statute. So, what have we seen in the state's presentation, Judge White? They have established motive. They've made it very, very clear that that has been their objective. And I'm not going to chase it because, as I've told the court from the beginning, that is not an element. It is not one of the facts and issue of this statute. By the way, one other thing that Ms. Benefield knew, Your Honor, on that day about Mr. Benefield, this would be from our exhibit number 4, Your Honor. Mr. Benefield's own statement, I promise you going forward, I won't do anything stupid, embarrassing, and insulting like I did with your waterworks or back early in the year when I put Eva's tracker on your car. Now, this is a woman who's not only experienced the shooting of the gun, the throwing of the gun, the punching holes in the wall, and a tracker on her car, but we also know about him being caught standing in the yard at night. And finally, Your Honor, there's this. A message from Mr. Benefield's first wife, whether true or not, this is what Mrs. Benefield believed and knew on that day. I love you, though finding out you weren't really what you pretended to be. You kicking me so hard on our New Year's Eve, on our honeymoon, because you were having trouble.
Which exhibit was that again? I'm sorry. I
That's-
remember reading it, but I don't know exactly.
Exhibit 4, Your Honor.
Thank you.
I'm sorry, Exhibit 7. I stand corrected. Text message from Renee Benefield.
Thank you very much.
So they've established motive, and that has been the evidence that they've presented exclusively. What they've established is that Miss Benefield wanted to keep Douglas Benefield from their child. They, in an effort to establish that, played the court's recording in the order from the domestic violence injunction hearing the first time. They presented the DCF allegations and, of course, Dr. Broder. From that, they want the court to draw the inference that the motive that they claim was created was sufficient for the court to infer that her decision would have been to murder Douglas Benefield. Now, that's a pretty good leap. Again, even though I don't believe it's a relevant element or an issue, to make the leap from resenting your spouse, fearing your spouse, concerned that you're protecting your child and wanting to keep your spouse away, making a decision to murder your spouse, you would think that they would need to have at least one witness who would come in and say, yeah, I was present at a party one time, and I heard her say, I'll be damned, I'll kill him before I'll let him see my child. Then I think you could make the leap. But instead, here's what the state's witnesses told us. Detective Warren told us about what Dr. Quintal had to say about Douglas Benefield. That he
I know.
used God to try and ingratiate himself. That he was a controller. That he was violent. Dr. Broder, that Miss Benefield told him she feared Douglas Benefield. That he was an intense personality, angry, a manipulator. And even, Your Honor, Attorney Stephanie Murphy. She was frank enough to acknowledge that in her practice, she's represented quite a few abused women, that the respondents against whom they seek protection are often violent, manipulative, and controlling. And you know how sometimes, Judge, in a conversation, somebody says something and it has the ring of truth. It just kind of hits you where you realize that it's a sound statement that's been made. Dr. Broder talked about appeasement and the strategy that Ms. Benefield used to deal with Douglas Benefield, knowing what she knew about him. By appeasing him, that was her way of best protecting her child, by going along with him, keeping him at bay. These were quotes from Dr. Broder, who was their witness. I'm going to tell the court that in this country, of the abused women that we know of that come forward, closing argument.
It's closing argument.
Of the abused women that we know of, Judge White, they generally tend to fall into two categories. They're either dead because nobody's listened or believed them, or they're in prison because they've taken matters into their own hands and they do not have the resources to fight back. And in this instance, thankfully, Ms. Benefield has backers that have enabled her to fight back. Well, it's very frustrating when I can't read my own notes, Your Honor. So, I would respectfully submit to Your Honor, there's very little about this arrest and charge that was either objective or proper. And I'm going to base that, Your Honor, on the detective, the lead detective, the quarterback of the team that the state called, and that would be Justin Warren. The reason I went through those two proposed affidavits and compared them to the actual affidavit he filed was, and I wanted the court to think about what reasons Detective Warren would possibly have for these actions. We know the affidavit that he filed. The affidavit that he filed neither identifies Douglas Benefield nor Barbara Russell, and alleges that the incident where Miss Benefield received a quote-unquote minor scratch happened on the day before the shooting. But in his two prior proposed affidavits, Your Honor, he has Douglas Benefield in there. He removes him. He has Barbara Russell in there. He removes her. And these, in addition, he maintains that the minor scratch, quote unquote, that Miss Benefield received happened on the day before, despite the fact that in interviewing Dr. Russell, she insisted that it happened the day of the shooting. And then finally, Your Honor, and here's, I think, the coup de grace as to his intentions. Somewhere along the way, not only is Douglas Benefield removed from the affidavit, but the word inadvertently is added to the scratch that Miss Benefield receives, which we articulate in our motion, and as Dr. Russell told Detective Warren, was incurred when Douglas Benefield intentionally and aggressively slammed that box into her side. So, I think Detective Warren's got basically two choices, Your Honor. He's either given us very sloppy, efficient, unreliable investigative work, or he's lied and he's misled the court that signed that warrant because it was consistent with his theory of the case. And what did we know about his theory of the case? Well, we know that he has a fundamental misunderstanding, despite the fact that he's a homicide detective, of homicide. He believes that all homicides are murders. A murder is a crime. A homicide is a death. There's usually an investigation, and the crime, if it's concluded by a fact finder, may be murder. He believes that all people who kill are murderers, regardless of whether it's excusable or justifiable. So how much of a fair and objective opportunity is Miss Benefield afforded by Detective Warren when in less than 75 minutes after the shooting, he's writing up a search warrant describing the reason for the search warrant, not as a homicide, but as a murder. And of course, it makes perfect sense because we know he believes that any killing is a murder. That's not enough, though. In addition, he misrepresents in his affidavit the two wounds that Douglas Benefield has suffered. He says specifically that self-defense has been ruled out because it does not appear that Douglas Benefield was facing Ashley Benfield when he was shot, despite the fact that the medical examiner says just the opposite. And what's worse is the medical examiner's opinion is released the day before Detective Warren files his arrest warrant. And you know, in the scheme of common sense, Judge, we've all been at this game for a while. Let's not kid ourselves. Detective Warren hasn't been sitting in his office waiting to hear from the medical examiner's office. He's called the ME's office and he said, so what do you got? You know, is there anything you can tell me? Is this possibly self-defense? So he gets the shot to the chest wrong because he says he wasn't facing her. And then he gets the shot to the knee wrong, but he gets it wrong because his theory is that Douglas Benefield was facing the closet when he was shot, which makes perfect sense. That he would be shot in the outside of his knee instead of the inside. And that's the warrant that he presents under oath to a circuit judge. And the reason he's removed Douglas Benefield's name, even though Detective Warren couldn't even bring himself to say that he's never had a judge question him about an arrest warrant before the judge signed off. I dare say, without knowing, that's certainly not going to be Your Honor's position. I would guess in time, if not already, the court's asked a couple of questions once or twice before signing an arrest warrant. He doesn't want that in there because an astute and street smart judge may say, well, what was the relationship between these two? Can you tell me a little bit more? Might this be self-defense? He's completely misled the court. I want to close, Your Honor, by reading two quotes, if I can. This is from a third district opinion, Your Honor, Guillermo Pinovar versus State of Florida, 338 Southern 3rd, 990. It's a February 2nd, 2022 case. Mr. Pinovar appealed the trial court's denial. The petition was granted and the trial court's order was reversed and quashed. The third DCA said the following. The trial court, based on its conclusion that Pinovar's motion below was not sworn and did not rely on record evidence, together with Pinovar's failure to present any evidence or testimony to support his claim of immunity, denied the motion. For the reasons discussed herein, we grant the petition, quash the trial court's order, and remand with instructions. A defendant's motion to dismiss under Florida's Stand Your Ground law can establish a prima facie claim of self-defense immunity from criminal prosecution, even though the motion to dismiss is neither sworn to by someone with personal knowledge or supported by evidence or testimony establishing the facts in the motion to dismiss. Your Honor, at no point in any capacity whatsoever has the state addressed the facts in our sworn motion to, in our Stand Your Ground motion to dismiss. They have not addressed what Ms. Benefield knew about Douglas Benefield on that day. They have not addressed his status as a forcible felon in the home of Ashley Benefield having assaulted her. I believe this motion compels the court to grant it. Thank you for the court's patience.
Thank you very much, sir.
I thought he was good.
Judge, the state has not addressed the facts in the motion because they're not evidence in this case. I believe we've all been doing this a long time, and the defense's argument about all of these facts that were known to Ashley, that's all written down, not sworn to, not evidence. The argument that was made might be okay for sitting around in a living room talking to your friends. However, the legislature and the Supreme Court of Florida have defined very strict laws for rules of evidence and what is reliable and what is allowed to be viewed as evidence. And an unsworn to motion written in the fantastical way that this motion is written, if the court has read it, then I'm sure you know, it is written more like a fiction novel than a legal memorandum. The legislature and the Supreme Court in no way would expect this court to take all of that as true, as substantive evidence. Not only is it substantive evidence, but the defense is arguing you have to take it as true. Anyone can write anything down on a piece of paper and submit it to you and go, well, you have to think it's true. So no, the state is not addressing these fantastical ideas that are in this motion. The state is addressing what is allowed by the law. And the law says that once the burden shifts, yes, everything defense counsel said about a motion doesn't have to be sworn to. It makes a prima facie case. And I'm sure Your Honor understands this. I don't know that everyone else does, but prima facie case only gets us here. It doesn't mean that all of that is proven and has to be disproven. It just means the burden shifts, and now the state has to show that she's not entitled to immunity or self-defense. Even if the court wanted to take what the defense said as evidence, what we just heard was Doug Benefield grabbed her arm and blocked her way, I believe is what the defense counsel said. In no courtroom would that be enough to shoot someone 3 times. Additionally, even with the state's evidence, she was the only one that was armed. There's no indication from anyone that Doug Benefield was armed. You saw the pictures of him laying there, dying on the floor. There's no gun next to him. There's no knife next to him. There's no, bat next to him. And you saw, like I said, the pictures of the defendant. And multiple times, she was not beat up. She did not have serious injuries. There is no reasonable belief that this type of force was necessary to combat imminent death or great bodily harm. And the state would ask you to deny the motion.
All right. Thank you both very much. Did you want to submit proposed orders? You don't have to. I'm just putting it out there. I know in some cases we do, some cases we don't. Oh, I'm sorry. Go ahead. Now, I did speak with the court reporter's office, and unfortunately, their staffing is a bit low right now, so it might be a little bit of time before I can get a transcript, because obviously, as we talked about, either side is going to appeal, so I figure we'll get a transcript anyway. That way I can cite to portions of the actual record in support. It might also streamline your appeal. So I will just say that I'll get an order out as quickly as I possibly can in light of all of those issues. That's September. No, she's listening in. Please should do that. I was joking how I tend to talk to the air because I know my JA is listening, and I said I wasn't going to do that because it looks weird. But so thank you for doing that. All right, thank you both very much. Excellent presentations over the last day or so. I appreciated the written product, the presentation.
No worries, Josh. That's fine. Thank you. He didn't give a date. He didn't give a date for when he was going to make a decision. I think he's going to go to trial. But I thought the defense had a good argument by the end. That's why I'm surprised that they didn't get her to testify or put something together. Because I generally think that they could really produce reasonable doubt. But they decided not to, so it's up to them. Can't do anything about that. So I think this is a September. So okay, this is definitely trial we'll be following. I think emotes some emotions with people, but hopefully, yeah, we'll put it on. Next, the one thing I will say though that I did like that I've never heard before, and Sarah agreed with me. I think it was about the investigator taking photos on the day of the defendant, but also like 3 days later of the defendant. I like that because it shows if a scratch has gone worse, if a bruise has come out, if there's marks that they missed and has now come out and stuff like that. So I was impressed with that. And the other thing that I thought was bad for the defense was the phone searches on the victim's phone about looking for a room in Maryland. So can they argue now that he wasn't going to move in with the family because he's Googling for rooms? So I don't know. Then went crazy, then people shouting back and forward, and I lost interest. Well, not I lost interest, but it was a bit like, what the hell's going on here? But anyway, that's where we are. Need to check one final thing here. Baby, let me go. Baby, let me go. Baby, let me go. Baby, let me go. Baby, baby. Right, I'm just checking. Dr. G explains. Over the weekend, it seems like he's deleted the Zachariah. Let's have a look. Scott Peterson, wrong one. Ooh. Coburger Laundry. I think he has deleted it. He's deleted the Zachariah Anderson video. Dr. G, you pussy. So yeah, so Dr. G has deleted the analysis of Zachariah Anderson. My plan was over the weekend. I was going to splice it to have Dr. G's testimony and then Dr. Lou, just speaking side by side, really. But that went out down the pan because there wasn't his testimony, so he's deleted it, the little pussy. So, but that's good news that he deleted it because he was a load of trough anyway. So the only thing I'm playing tonight is Lou. I know some of you have watched it already. That's totally fine. But if you want to join, it's about 35 minutes. It is. I've listened to it about 3.5 weeks ago. She messaged me with it to see if it was okay. I was like, yeah, it's fantastic. And then she posted it. And yeah, if you've seen it, we can watch it again. Do you know what I mean? So I haven't got the original Dr. G video to go against it, but I think she does a good job of explaining it. About 35 minutes long, and then we'll have a hopefully brief chat afterwards about some of the upcoming cases. What's interested to people? What do you fancy? I want to do a trial after show business that's hopefully not online and like a quiet one, not quiet one. I'm trying to say a smaller one that won't get much exposure. Like I'd like to do one of those again. You know what I mean? So like Kara's one. So yeah, so that's where we're at. Jeez, I'm tired. What's wrong with me? So that's the end of that one. I think it's going to go to trial. We'll have to keep an eye out on that one, see when the judge makes his decision. We'll definitely follow it in September. And we go to business next week. I'm not sure what we're doing the rest of the week. I think Wednesday we're going to do like a news flash thing. We'll see. Anyway, so with that, I'm going to end the stream now and then hopefully see some of you at 4 o'clock Eastern. If you're around to look at Lou's video. Unfortunately, she can't come on because she's working. But she did say that if there's any questions that people have got, she'd happily come on another time with me to do a live stream to answer any questions. So we'll see. Oh, excuse me. I'm now going to get I'm going to make some toast with cheese and toast. I'm not going to put beans on it or nothing like that. I'm just going to make cheese on toast. Very British, so toast, butter, and cheese. That's it. Keep it like that. I haven't got anything to put on it, so I'm going to keep it like that. So thank you, lovely people, for being here. And yeah, I'll see you in about 2 hours, 10 minutes, something like that. Gives me a little bit of a break and some food, and then let's get it on. Anyway, right, thanks for that. And I shall see you later, guys. Again, thank you to Wendy for the super sticker. Appreciate you, Wendy. Okay, with that, take care, guys. Catch you later on in a couple of hours. Ta-ra. Love you all. Ta-ra.